We good? Excellent. Welcome for Wednesday, February 11th. It's the Economic Matters hearing. We have 6 bills, and we're going to begin with House Bill 485. Delegate Johnson. Begin when you're ready.
Good afternoon, Madam Chair, Vice Chair, members of the Economic Matters Committee. For the record, I'm Delegate Steve Johnson, here to present House Bill 485, State Board of Professional Landscape Architects revisions. The bill updates and strengthens how landscape architects are regulated in Maryland, clarifies the conditions under which they practice, and brings the state board in line with current professional and administrative standards. House Bill 485 makes several changes to the state board itself. It replaces licensed landscape architects with professional landscape architects throughout the statute and renames the board to the State Board of Landscape Architects. The bill maintains the board's current structure of 5 members while modifying its experience requirements to allow for a younger voice to serve on the board. Additionally, House Bill 485 provides emeritus status and defines the appropriate qualifications. The bill updates the responsibility of the board to support better governance and the Board of Professional Landscape Architects. House Bill 485 does not expand regulatory authority, but makes important improvements to the existing regulatory framework. This legislation will modernize oversight and professional landscape architects in Maryland, benefiting both practitioners and the public. For those reasons, I urge a favorable report on House Bill 485.
Thank you, Delegate Johnson. Good afternoon, Chair, Vice Chair, and members of the committee. I am a native Hartford-Countian, and I also live in the Vice Chair's district. My name is Grace Fielder. I'm representing myself as an individual and as president of Grace E. Fielder & Associates, a firm I founded in 1991. I serve on the Board of Examiners of the Landscape Architects. However, I am not speaking for them or representing them today. The bill that is before you will better align Maryland's landscape architects with our fellow disciplines of civil engineering, land surveying, and architecture. First and foremost, as we modernize the law, we continue to respect health, safety, and welfare of our residents and the public. And very specific, we update the name of the board to the State Board of Landscape Architects. Licensed landscape architects become professional landscape architects. The experience for the board members have been lowered so we can have a younger voice. We're also revising the outdated language that appears in the current statute, which was developed in 1971 when it went into effect. This ensures that only qualified individuals practice in areas that affect land use, community spaces, and environmental outcomes. I personally was licensed in 1978 under the original statute. I was the 15th woman registered in the state of Maryland of landscape architect. We now have 975 practicing landscape architects. For all these reasons, I respectfully request a favorable report on HB 485, and I'm willing to answer any questions that you might have. Thank you for the opportunity.
Seeing none, thank you very kindly for your testimony. Oh, we have a virtual? Oh, I'm sorry, you don't have your mic lit, so I didn't see you.
Hi, thank you, Madam Chair, and thank you for bringing the bill. I just had a question. You said you were the 15th woman in this industry, and then you went to the 900 and I think 70.
Well, there's currently 975 that hold licenses in the state of Maryland as individuals. But the number's well over 3,000 at this point. The numbers are continuous.
Oh, that are doing it without licenses?
No. it started with number 1, and every time an individual is licensed, they're given a number, a license number. Mine was 387. There's now over 3,000. But there's current licensees. There's 975, as I understand.
Okay,
Some retire.
Yes, there you go. Some of them retire.
got it, got it. Do you know how many women there are now?
We're well over 50%
Okay.
in landscape architecture. When I first started, there were very few women that practiced at all, and I was into about my 30th year of work before I sat in a meeting that had all women. But I've loved the profession.
Yeah.
Guys are great, too.
Yeah, thank you. Thank you, Madam Chair.
Real quick, you mentioned something about the fees. It says under current law, and you say there'll no longer be, the non-refundable fee will not be paid to the board. Who gets that fee now?
It goes to the department. All the fees go to the department, as far as I know. They don't come directly to the board.
Okay, so, but the board was getting these fees, now you're saying it's going to the department.
I'm sorry, I'd have to go back and find that specific language.
Set by the board, an examination fee by the board, maybe it's not saying that, but all those go right to the department, you're saying?
The examination fee goes to those that are administering the exam itself.
Okay.
In this case, it's CLARB, Council of Landscape Architecture Registration Boards. Thank you for clarifying that question.
I got you, thank you.
Seeing no additional questions for the panel, thank you, Delegate Johnson. That concludes the bill hearing on House Bill 483. We'll now move on to 485. We'll now move on to House Bill 483. Delegate Wallach, if you have your panel with you, you can bring them up.
Hi, good afternoon. This is my first time visiting ECM, so it's lovely to be here. Good afternoon, Chair Walderama and Vice Chair Charkoudian and esteemed members of the Economic Matters Committee. For the record, I am Delegate Sarah Wallach, here to present House Bill 483, Business Regulation, Charitable Organizations, Audit Review and Thresholds. Thank you for the opportunity to testify today in support of this bill. Under current law, charitable organizations with at least $750,000 in gross income from charitable contributions must submit an independent audit, and those with at least $300,000 but less than $750,000 must submit a CPA review. This bill raises the thresholds to $1 million for audits and $500,000 for reviews, while preserving the Secretary's authority, and that's the Secretary of State's authority, to require additional financial documentation when appropriate. These thresholds were most recently updated by Senator Seminare's SB 10 in 2016, so it's been a decade since that updating, and that updating in 2016 was preceded in 2009 by Senators Colburn and Brinkley's SB 806. Both of those bills in each of those years received unanimous bipartisan support in both the House and the Senate. And in the nearly 10 years since, inflation has been rising. As you all well know, the operational costs have significantly changed for nonprofits. And this bill ensures that our regulatory standards keep pace with today's economic realities rather than relying on outdated benchmarks. So HB 483 modernizes Maryland's charitable organization oversight requirements by updating these thresholds that trigger external audit and review obligations as part of the annual registration with the Secretary of State. According to the Secretary of State, around 1,700 organizations would benefit from this increase in threshold, and they will be able to divert those resources to helping their communities and really the purpose of their work. This is simply an incremental bump, and it does not take away the Secretary of State's authority in any shape or form. Should they choose to pursue any further audit there, continue to be able to do that. Thank you so much for the opportunity to present this bill, and I would urge a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. For the record, my name is Teresa Hessler, Ashler Government Relations, and I am here today on behalf of Maryland Nonprofits, a statewide association representing nearly 2,000 nonprofit organizations and institutions across Maryland. We are in strong support of House Bill 483. House Bill 483 makes a reasonable and overdue adjustment to the financial review and audit thresholds, as the delegate mentioned. It will not have charities. They will still continue to submit their IRS Form 990s, and as mentioned, it does not limit the Secretary of State's authority to require additional documentation, including a full audit at any time. Maryland Nonprofits has long supported strong charitable oversight and consumer protection. In fact, we proposed the registration fees increases that enabled the expansion of the state's charitable enforcement program and the launch of the modernized online registration system in 2022. House Bill 483 builds on those efforts by addressing a significant compliance cost that now affects well over 1,000 compliant charities in our state. Since that time, both the cost of living and cost of professional financial services have increased by roughly 1/3. Adjusting these thresholds simply reflects that reality and ensures that compliance requirements remain proportional and appropriate. For these reasons, we are in strong support of House Bill 483 and the targeted relief that it will allow nonprofits without weakening oversight. Thank you.
Turn this one on.
I think it's on.
Good afternoon, Chair Valderrama and Vice Chair and committee. My name is Peter Kimbus, and I'm here in the capacity of representing Nonprofit Montgomery, an association of nonprofits within Montgomery County in the great state of Maryland. Have you ever faced a situation where you're faced with danger? Delegates. And in that space, someone then intervenes on your behalf, occupying the space between you and the danger. That's what we're talking about here today. The nonprofits that we're talking about are ones that protect Marylanders from domestic violence, poverty, homelessness, hunger, food insecurity, and more. This bill, HB 483, is a common sense step that aligns with federal initiatives at OMB. The move that this bill is asking of you is to focus more on people than on paper. It's not a deviation, it's just a modernization of current code that's outdated. We're moving from 2016 to update according to the realities of 2026, where nonprofits are facing increased competition, decreased funding, and an increased need of services and demand. In this new economic reality and climate, where those organizations that are the very protection for Maryland citizens, we ask for a favorable result for House Bill 483. Thank you.
Thank you. We'll start with Delegate Pippy.
Thank you, Madam Chair, and Delegate, good to see you. Good to see panel. Question. So looking through the bill, it looks as if it's I mean, it's a pretty simple bill, but it's moving the brackets of when a nonprofit would have to do an audit. Is that fair to say? So
That's correct.
Currently,
yeah, it's review and an audit.
Yeah, review and an audit. So up to a certain dollar amount. So those amounts have increased, which one could argue maybe less organizations would be required to do these audits because you're increasing the dollar amount to require an audit or review. So the only reason I bring this up is because there's been some news lately in Maryland about a lot of charitable organizations that have failed to do audits. And I don't know if you've been following those or maybe could at least chime in on how this bill would kind of be in play with that issue.
Yes, thank you for that question. So the concern that's been raised specifically, I think that you're referring to, is with regard to government dollars, so state government dollars that are flowing to nonprofits, and the government, the responsibility of the state government to be able to identify where those dollars are going. So that is sort of the onus is on the state government, not on the nonprofit. So the challenge isn't, this bill isn't going to impact the state's responsibility in oversight about where state dollars are flowing. This is simply their own monies that they have and whether or not they're going to do it. It's not going to solve the problem that you're pointing to. Does that?
It does, yeah.
Yeah.
So it sounds like two different folks doing audits, right? One is maybe a requirement of the charitable organization to do their own audit. The other one is the state doing audits of who they're giving money to.
Or I would say probably having better track of where the money is going, yes. The audit can follow, but we can have also just oversight about where the money is going. And I believe that has been something that has to be strengthened.
Okay, all right, thank you.
Delegate Adams?
Thank you, Chair. So in follow-up to what Delegate Pippy was talking about, I just had a couple of additional questions. The work that any nonprofit does, whether or not it's getting audited or getting a review level statement from a CPA, isn't the work the same? I mean, don't nonprofits want to have a high level of accuracy, receipts of cash received, a detailed way the monies are being spent? I mean, doesn't this happen free of whether it's an audit, whether it's review level?
That's correct. I mean, a nonprofit has to have a board and an oversight, and they are probably having some level of oversight that they're providing. Whether or not they have to expend monies to do that and hire external parties to assess, that adds to the cost, which is what this bill is trying to address, right? So a board, a CEO or an executive director of a nonprofit is very well responsible to do that oversight that you're pointing to, but not necessarily having to hire an outside entity and expend tens of thousands of dollars to do that oversight.
So I think that's the right answer, because irrespective of whether an audit comes from the IRS or comptroller, or whether it comes by virtue of a requirement of the legislature, the work that the nonprofit does should be the same. It doesn't cost any more, any less to treat the money correctly in an accounting gap or whatever the standard is nonprofits are subject to. So the follow-up question, which I think goes to the concerns that the legislature is having, is that there's not going to be a large cost difference between a review level statement and an audit. It might take a few more hours for an audit to be done. We're not talking about a nonprofit that's got $30 or $40 million a year in receipts. We're talking about smaller nonprofits, and $1 million of charitable contributions or $500,000 of charitable contributions is not this is not a large organization. However, I think that there is, if you're a person that donates these monies to these organizations, knowing that an audit or at the minimum a review level statement are being produced adds credibility, one, but two, allows people to know that they're putting these monies in these nonprofits and that it is being reviewed at a third party level. And so your bill is talking about money rather being spent for an audit or review going into the coffers for better services. I'm saying that, and wouldn't you agree then, that people that donate money to nonprofits want to know that that money is actually going where it belongs, being spent the way it should be spent, and most importantly, that the cash is being treated correctly. That's the purpose of an audit.
Right, so again, it doesn't absolve the leadership of the nonprofit to do their due diligence in managing the organization's monies. This bill does not say anything with regard to that. That is still ongoing. Whether or not they have to expend, again, tens of thousands of dollars as a small nonprofit for an external review is the burden that we're trying to alleviate and essentially maintain the standard that we set 10 years ago at 2016, and just adjusting the number, that threshold that we've sort of come to agree to for 2026.
Well, thank you for letting me probe on these questions. Nonprofits are certainly important, so don't misunderstand the nature, but I think in the world we live in today, If I were serving on a board of a nonprofit, I'd be handing financials to a third party and saying, hey, you make sure. I mean, I don't want to be on a board that can't say, I've got an independent third party that's doing it, and I don't know that it matters how much money we're talking about, but thank you.
I've got a response too.
Okay. Delegate Aaron's and then Wyval.
Just following up, and I think that Delegate Adams kind of hit the nail on the head. In today's world, especially with what you're reading about, don't you think oversight's more important now than ever? And I would probably rather spend the dollars to be upfront and honest with my investors. I know my wife and I do some work with some nonprofits, and that's one of the things we've talked about on board hearings is trying to have that accountability to actually go out and draw more, because if you have the accountability, people are more confident in investing in those nonprofits. Wouldn't you agree?
I don't disagree that the responsibility of leadership in a nonprofit is to steward the dollars and then also create the impact, the reason it's been stood up. And so it doesn't, again, the bill doesn't absolve them from doing any of that. It's just being consistent. There's no change essentially because we have a threshold that is outdated for inflation. So all we're doing is adjusting it for inflation. The nonprofits that sort of fall within the current structure would remain, so we're just adjusting for the 10 years that have passed.
In an ideal world, I would agree that it'd probably be that way, but not all nonprofits do the right thing every time. And I think it's important for the people that actually contribute to have a better handle on that. I'm fine now, thanks. Thank you.
Chair, thanks for the bill. Just this one simple question. Do you know how many nonprofits would be impacted by the increased threshold?
So when we had a conversation with the Secretary of State, they indicated that about 1,700 will be impacted. Okay. And I'll just also give an example. You know, oftentimes these tiny, tiny nonprofits may have 0 paid staff, and most of the money is going out the door. Right? So to your earlier point, the money isn't necessarily being paid for high salaries, pay for overhead, travel, or the kinds of things when we think about money being, misused. Essentially, they're tiny, and what they want to do is get that dollar to the person who needs it. And they're simply a conduit. So the way some of that may be mismanaged, it doesn't necessarily even apply to these small nonprofits. Some of them might be getting food at the door, and they're simply taking the money from donors, purchasing the food, and getting it to people who need it. So we're not talking about large entities where some of those challenges may exist. So hopefully that paints a little bit of a picture.
And do you know the total number of nonprofits registered in the state?
Off the top of my head, I do not. Do either of you?
I don't, but I'm happy to get you that answer.
Okay. All right.
And to add, so agreed, delegates. And what this bill is proposing is not a deterrent or an aberration from due diligence and fiscal oversight. A financial review, as you're aware, provides independent check without the crushing cost of an annual full audit that's mandated. We're talking about organizations of $750,000 in total revenue. If you've ever run a business, you know that's not a huge amount. And when we're talking about the cost of a full audit over a review, $15,000 to $20,000, it's a huge percentage.
Thank you, Mr. Kimbis. I will just remind the panelists and those who come forth that unless a question is directed to you, we won't be having going back conversation. So I appreciate your additional testimony. With that said, Delegate Rogers.
Thank you, Madam Chair. And this is for the sponsor. Would you say that what this bill is really doing is updating the legislation to account for inflation that has occurred over the past 10 years?
That's right.
Thank you.
Okay.
Okay. Seeing no additional questions, thank you very much.
Thank you.
And seeing no other witnesses, that concludes the bill hearing on House Bill 483. Hope you had a good first time, Delegate Wallach.
I did. I'll be back, so thank you.
Great. With that said, members, we're now going to move on to House Bill 433. Delegates Chi and Adams, well, Chi. If you have your panel, Delegate Chi, they can come up.
Good afternoon, Madam Chair, Vice Chair, distinguished colleagues of ECM. I am Delegate Lily Chi, here to present HB 433, Business Regulation Collection Agencies Licensure Exemption for Property Managers. This bill exempts property managers from the requirement of a debt collection license under the Maryland Collection Agency Licensing Act, MCOLA. The reason is simple. Property managers perform a myriad of other essential functions like marketing and leasing, property maintenance, tenant management, compliance and reporting, etc., that are far beyond rent collection and should not be treated the same as debt collectors whose primary or only duty is to collect debt for another party. In fact, the Montgomery County Circuit Court recently ruled that Maryland's legislative history on debt collection makes it clear that the legislative intent for the Maryland Collection Agency Licensing Act is to regulate debt collectors, not property managers. For nearly 50 years since the enactment of MCOLA, property managers were not required to be registered under that law. So why all of a sudden the change? Because in 2025, the Attorney General's office issued an opinion stating that they believed MCOLA applied to property managers. Now, I have to point out that the opposition, which you have probably seen many letters, will try to convince you that without this licensing requirement, property managers are not otherwise subject to any regulatory oversight or consumer protection laws because they don't have another separate license requirement to operate in Maryland. So let's look at the facts. Property managers are already subject to Maryland's housing laws, landlord-tenant laws, and the consumer protection laws, as stated in the Maryland Tenants' Bill of Rights, in addition to local county laws. In fact, property managers are regulated by the Maryland Consumer Debt Collection Act. Let me repeat. Property managers are regulated by the Maryland Consumer Debt Collection Act, MDCA, which is the Maryland version of the equivalent federal law. MDCA regulates any person collecting or attempting to collect a debt arising from a consumer transaction, including property managers. When you hear the examples of some bad actors, there are some horrible stories, right? But many of the terrible acts listed in opposition's testimonies are already regulated under MDCA, which prohibits conducts such as claiming money you are not owed, fraud, harassment, disclosing tenants' personal information inappropriately, and false pretense as like a legal proceeding when it's not, right? These are already prohibited. Most of the counties in Maryland also already require rental housing licenses, including the biggest ones that account for much of the rental housing market, like Montgomery County, Prince George's County, and Baltimore City. So this bill simply clarifies that property managers should continue to be regulated as housing professionals under the existing laws for consumer debt collection, not as another class of debt collectors who are in the business just to collect debt. I want to call your attention to the testimony of the Housing Authority of Baltimore City, which is a public housing authority, I want to point out, not in the business of making money. Their support letter makes it clear that while rent collection is a standard function of property management, it is not the primary purpose of the agency that oversees affordable housing for low-income tenants. Therefore, they support the elimination of another administrative burden and overhead costs. Finally, I want to say that over the years, I have introduced and passed several bills on consumer protection, which is an important part of my work and will continue to be. In fact, my next bill is about consumer protection. So while I appreciate the passionate advocates' opposition in good faith, I would urge everyone to refrain from impugning the sponsor's intent or suggesting that we are trying to let bad actors get away with terrible deeds. We need our government agencies to do their jobs enforcing the existing laws consistently and fairly rather than adding more confusion and burdens to the good actors in our community, providing housing and essential services to our community. Thank you for your consideration.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in support of House Bill 433. In Maryland, collecting current rent under an active lease is not debt collection. It is enforcement of a present housing obligation. Failure to pay rent actions under the real property article result in possession. It results in possession, not a money judgment, and therefore does not involve the collection of consumer debt. The Maryland Collection Agency Licensing Act, original purpose in 1977 was to regulate licensing and practices of debt collection agencies, not to regulate other professions that incidentally collect payments as part of their business. The statute targeted those agencies in the business of buying and collecting third-party debt by requiring a license and bond to do such business. MCALA was not intended to provide broad consumer protections regarding businesses who seek to enforce their own obligations. Those are more accurately governed by the Maryland Consumer Debt Collection Act, as Delegate Shih highlighted. There is no question that the Maryland Consumer Debt Collection Act applies to property managers, and this law protects against a landlord claiming a right that they do not have, fraud, harassment, or the like. I do want to highlight, which is in your file, the Smith v. Bizzuto case that Delegate Shih highlighted, the Montgomery County Circuit Court case. The judge provides an analysis and applies a primary purpose versus incidental activity test to determine if someone is a debt collection agency under MCALA. The correct question is whether debt collection is the primary purpose of the business, not whether the business ever collects money. Rent collection is an incidental component of property management, not debt collection. Federal courts agree. In Young Bay versus Southern Management Corporation, a federal district court similarly found the same thing. For those reasons, we respectfully request a favorable report on House Bill 433.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Brian Anley with the Apartment and Office Building Association. AOBA represents 122 property management companies in Montgomery and Prince George's counties, and we agree with the comments made by the sponsor and the other panelists that you're going to hear from today. I want to address a few points that you're going to hear from the opposition. First, as Delegate Shih mentioned, that there's already rental housing licenses that apply at the local level. The opposition claims that those really deal with habitability, and while that's generally true, Montgomery and Prince George's County, again, the two largest that represent a third of the state's rental housing stock, have recently expanded in the last year rental housing, or rather consumer protections to rental housing. So that's already covered. Second, there's an existing exemption for real estate brokers in MCALA. And the Department of Labor's position is that that exemption doesn't automatically apply, for example, to a property management company that employs a real estate broker. The real estate broker must still be licensed if they collect debt and work for a property management company, and or the management company has to then apply for an exemption from the law, which is, you're going to hear from today, it's very cumbersome to do. And then third, many of the examples that you will hear about regarding deceptive trade practices, as Delegate Shih mentioned, are already covered by other statutes, the Maryland Debt Collection Act, but also the anti-retaliation statute. So threatening to call ICE on a tenant, refusing to make repairs, calling a renter's employer, and all these other things that you're going to hear about, those are already covered as part of the anti-retaliation statute. And they may even constitute criminal extortion under the criminal law article. So tenants already have broad protections from a lot of these behaviors of supposed bad actors. Lastly, we've talked a lot this session about competitiveness. We need to make it easier to operate housing in Maryland. Neither Virginia nor DC have a licensing requirement for debt collection. For these reasons, we urge a favorable report.
Thank you, Chair, Vice Chair, and committee members. My name is Sandy Peck. I'm the General Counsel of Tower Construction Group. We own and operate properties in Montgomery County, commercial, retail, as well as rental housing. I've also served as a legal executive in 2 other property management companies based in Montgomery County. Prior to going into property management, I have spent a significant amount of my legal career in financial services, both in green banking as well as at Freddie Mac in their legal division, doing approximately $2 billion in multifamily targeted affordable housing loans. When I reviewed the Maryland state licensing regime regarding the debt collection licensure, it's clear to me that they're financial regulation. Maryland's Office of Financial Regulation regulates financial institutions and financial services providers. Their website directs licensure applicants to the nationwide multi-state licensing system, which is a system of record for financial services licensing. This framework is designed for licensing for financial services operations. Property management operations are not financial services. A typical property management operation requires that we employ a number of professionals to constantly work on the building infrastructure, the building systems, the interior, maintaining the interior of the building, as well as managing leasing operations. There are extensive federal, state, and local regulations that govern rental housing operations. They dictate what must be included in residential leases, the processes by which a landlord can enforce their lease when a resident violates their lease obligations under the agreement, and they also enumerate various tenant rights. In short, property management for residential housing is highly regulated. We are facing many economic challenges right now, and thank you so much for your time.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Brian Alford, President and Chairman of Grady Management. Grady third party manages 34 communities consisting of almost 8,000 apartments in the state. I agree with the panelists that management companies should not have to have a debt collector's license because our main function is not debt. Our main function is managing the communities, managing the people, and providing quality homes and communities to the residents that live in them. If we have a resident that moves out and owes money, we use a third party, a debt collector, to collect that or attempt to collect that. We do not collect debt. Nevertheless, because of the pressure of having to obtain one as a property management firm, I have, through an attorney, tried to attempt to get this license for the past 6 months. To say the least, this has been very cumbersome as well as costly to us as a management firm, and we still haven't yet to obtain a license. The reasoning being that we use a national platform that then tries to tie into the state platform, and none of the questioning or what we have to provide covers or is geared towards property management. It is towards financial institutions. On top of that, the ask is for detailed personal information, including our personal housing, passports, driver's license, as well as a resume which is geared to be a financial collector, which I'm not. My resume and my history for the 32 years in this industry is based on housing and providing professional housing and services to the industry and to the residents. It also asks for very expensive business plans and documentation related to our environment that is not management or property management geared. Thank you for your time today.
Thank you. We're going to start with the Vice Chair, then Delegate Queen, and then Delegate Adams and Roberts.
Thank you, Madam Chair. So I'm trying to understand what licensing there is for property managers. I know there's, under certain circumstances, there's a real estate license. And then right now, under all circumstances, if there's rental collection, then there's a debt collection license. But there's a bunch of folks who, if we got rid of this, wouldn't have a license. Is that right, of any kind? I'm asking anyone, I'm trying to understand. So if we got rid of this, would property managers have to be licensed? I know that some property managers have to have a real estate license for certain things that they might do, right?
So
Am I
a
right
property
about that?
management company, and perhaps Mr. Alford can speak to this a little bit more specifically, a property management company can employ a broker that can work for them. So that's one type of license. They also have to have local rental housing licenses.
Right, but
that's
from a
second
state
type.
perspective. So here's what I'm asking. If from a state perspective, we were to get rid of the debt collection license, would there be any other licensing structure? I understand there's regulations they would operate under, but would there be any other licensing structure that property managers would be operating under?
Not statewide, no.
So I think that's my concern. Like, I would be open to the idea of getting rid of this if we had a property manager license. But the idea that property managers who have such like, if I didn't spend half of my time, wrestling with property management companies because, there's no heat, there's no air conditioning, there's no, there's literally showing up at buildings with popsicles in the middle of the summer to, give to the children and then go try to find a property manager to figure out what's happening with the air conditioning and a heat wave. Like, if I didn't spend so much of my time dealing with these things, chronically, all the time, same buildings, I might be more open to an idea of removing a license requirement, but I just feel like, and maybe this isn't the right license. Like, I hear you that maybe it's not the right license, but I feel uncomfortable taking a licensing requirement away of something that gives a licensing oversight without having something else, that would license essentially property managers. That might be a better fit than this one. So, like, I hear what you're saying about it doesn't feel like it's a good fit. I just feel like if this is the only licensing we have, we probably need to hang on to it until we get something that's a better fit.
If I may, Madam Vice Chair, all the things you just enumerated, those are all covered under Montgomery County's existing rental housing
I'm aware, and despite that, I'm in the buildings, I'm calling DHCD, they're running around with their thermometers like over and over and over again. I'm well aware of what is in the law. What I'm saying is it's not sufficient. So, like, the laws that we have in place are not sufficient, not across the board, but I'm not going to name the buildings now, but I'm happy to give them to you later. Like, over and over and over again, the same buildings, the same issues, and the fact that we have laws that regulate housing is not sufficient. And so, to the extent that there's some license, something that gives us an ability to influence, take away, a complaint structure, those kinds of things, again, I hear what you're saying. It doesn't feel like it fits, but it's the only thing we have. And so I would ask us maybe to leave this in place and come back next year with a property manager license and then get rid of this or something like that. Anyways, happy to work with the sponsor on that. Thank you.
Well, most counties in Maryland already have their county level license, and you have to operate in one of the counties. So you have to comply with the local licenses already. So whatever you conceive of as another form of state level license, we'll have to look at what counties are already regulating without duplication, right? Or undue burden. That's usually the problem with the Maryland, and causing a lot of overhead and confusion. And the kind of examples you mentioned, they're already regulated. Maybe it's not a matter of licensing as much as enforcement of existing laws by local jurisdictions.
Thank you, Madam Chair. Thank you, sponsor, for bringing, having us think of bills differently. And I appreciate your comment about just because you bring a bill together, that doesn't mean you're trying to hurt other people, allow other people to be subject to less oversight. My question, though, is related to the letter from the Public Justice Center. They seem to suggest that there is some litigation going on and maybe we should wait until that's settled before we make any changes. Have you looked at that or have any thoughts on that?
Yeah, we have seen, I saw the letter yesterday, yeah, but the Montgomery County Circuit Court already ruled. I know there's an appeal.
Okay.
The legislators can decide.
Okay, understood. And then I guess the two organizations I would be concerned about that had unfavorable is the Office of Financial Regulations as well as the Office of Attorney General. What has been that dialogue with them in terms of, because it seems to be
well, so the AG has to be consistent with the opinion they issued, right? As I said, it was not an issue until a senator, because my understanding is in recent years, the AG started lumping property managers under certain categories as if they were debt collectors. And then the senator reached out asking for the AG's opinion, and the AG issued an opinion saying they should be part of, subject to MCALA. So you can chime in.
But how about the Office of Financial Regulations?
So my office reached out to Mr. Tony Salazar and his team, and it's interesting that for a department that is supposed to regulate or license or enforce that. They don't really have any data about who is licensed and who is not, which means this is a very confusing kind of scheme, even for the people who are supposed to be doing their job. And it could be crossing two administrations too, or many administrations. We're talking about 50 years of history.
So this may hit to enforcement is not, the licensing may not be the issue, but enforcement may be the
principle, they said, yeah, they should be categorized as debt collectors. But when I pressed to say, tell me who is actually has applied, or what kind of data do you have, they could not turn out anything. Yeah.
Thank you, Chair. So, Delegate, thank you for the bill. I mean, there are so many bills that we pass in Annapolis that seek to clarify and bring bright line paths to compliance with laws. The nature of the bill, as I understood it coming in, is that the AG's office was confusing the relationship and the nature of what we've been doing for decades. I mean, we're talking about something from 1977 or 1980 that's getting a new, fresh review. This isn't a bill that we passed last year to create this debt license. This is something from the 80s, and to be blunt, there are a lot of property managers that have been doing business without this novel mechanism that was used in this court case that we're talking about. So on more levels than that, I support the bill and thank you for bringing it, but for no other reason than to say that this doesn't take anything away from the protections that we give to tenants. It rather clarifies and brings paths to compliance with the property managers who are being complicated by this fresh interpretation. So thank you for that. I guess my first question, Aaron, you brought up the issue of possession, judgment for possession. Could you tell me the difference from your perspective as we look at this bill, the difference between a collection on a mortgage that doesn't get paid versus the landlord that's in court seeking a judgment for possession, and why one looks and feels like debt collection and the other doesn't?
Yeah, it's a great question. As I said in my remarks, landlord-tenant law is really governed by Title 8 of the landlord-tenant of the real property article. And when a tenant fails to pay their rent, you file what's called a failure to pay rent action under 8401. The only thing that you're granted is, if you prevail as the housing provider, is judgment for possession of the property. So you don't get a money judgment, which if that were the case, maybe we'd be having a different conversation about this bill, okay. But you're getting judgment for the possession of the property. And so that's a very... Speak to the microphone. Oh, so I'm sorry. So you only get a judgment for possession of the property versus the mortgage, where you get a collection. You get collection on what's owed in the mortgage, right?
Right. So the point of that question is that this doesn't pass a sniff test just from a business regulation standpoint. This isn't the collection of a mortgage. This is the possession of property where a tenant has violated a provision of the lease, which frankly includes, you got to pay the rent. My second question is, and it goes to the fairness component to this, explain how without this bill's passage, there will be a series of business owners, because of how the Attorney General is going about this, that could in theory be in violation of law and action by the AG if we don't act in this legislative session.
Yeah, so part of, and Mr. Alford can certainly speak to this, part of the application process in this national multi-platform system is, how long have you been conducting this business? How long have you been, in other words, how long have you been collecting rent, right? Mm-hmm. And so if you're a housing provider who now sees action by the Attorney General's office that you could be in violation, and you go and try and do the right thing as Mr. Alford's trying to do, and you realize, I've been doing this, my company's been doing this for 50 years or 30 years, you then expose yourself to action by the Attorney General's office, the Office of Financial Regulation, and even worse, plaintiff's counsel, and that's where you get the Smith v. Bizzuto case, which is in your file.
Right. So in other words, the fairness component of this bill and why it's being brought is on multiple levels, but one of the most important ones is the fact that if it weren't for what's happening right now in this novel interpretation, you might have hundreds of or thousands of property managers that'll be subject to enforcement action. That's just not going to, that will not pass the sniff test here in Annapolis, I don't think. I think most people will view landlords as providing an essential service, and being singled out on the technicality of a situation like this is untenable in my estimation. I guess my last question on this, and that goes to, and Aaron, I'm only going to you because we can ask somebody else this, but you've got these layers of laws. You brought up Title 8, which is the real property article. Here are a layer of protections for the tenants. The relationship between landlord and tenant gets described. Violations are put forward, and what those look like from a penalty standpoint. As we continue to layer things like you brought up, the Maryland Consumer Protection Act, which I think is another layer, is this not adding like this third but brand new layer that if we don't pass this bill now, because of what the Attorney General is doing, are we worried about there being conflicts, or where these multiple different layers of regulations just don't mesh well, and therefore the whole idea of having clear, bright line paths to compliance to law completely get violated, which is why we're here today. And I think that's, speaking for myself, I think it's one of the main reasons why I think this bill relates, because of this general idea that things are getting stacked on, and this one is one we can't allow the AG's office to allow to stack on top of all these other regulations that are in place that the state of Maryland has considered and do protect tenants from wrongdoings that are legitimate, formal, and have every right for a tenant to go to court and get action.
If I may respond.
Yes, please. To you.
So one thing I would point out in terms of this licensing regime that is looking for property management companies to qualify and license as debt collectors is it's a different set of skill sets. It's a different professional that you'd be hiring to conduct that service and qualify for that license. And if there are a number, in terms of the Real Property Code, there are 9 subtitles in the Real Property Code that deal with landlord-tenant law. 3 of those deal with rental housing in particular. So, and then on the federal level, we have fair housing and we have credit laws that we have to all comply with, but they aren't licensure regimes. So trying to create a licensure regime that is really meant for financial institutions and push that into property management is, I would say, fairly unwieldy to manage from a operational standpoint.
Thank you for the bill. It's here for the right reasons, and look forward to ongoing conversation.
Thank you, Madam Chair. I guess I need some clarification on some things. So we're just talking about property management for rental properties. So that would not cover, say, condominium association property managers? No?
I believe this is just rental property. This is just rental property.
Just rental properties. You mentioned, you were making a comment and I'm giving an example of failure to pay rent, and you said possession of the property, but the failure to pay rent does result in a judgment of money. Well, usually if the tenant is behind on their rent, it is a judgment of money, correct?
Well, no, it is not. It is a judgment for possession. You can go later in a separate action, correct me if I'm wrong, Sandy, and collect that owed money from the rent. I also want to point out that this bill is very narrowly tailored to only during the enforcement of a lease. So this is not post-eviction. Post-eviction, we can understand why you might need a debt collector's license. But this is only, if you read the bill carefully, it's only during and for the enforcement of a lease.
Okay. So, okay. I was thinking, so you're only talking about when you're suing for possession, because I thought failure to pay rent was just trying to get the rent.
if I may respond a little bit about the logistics. Sure. So a failure to pay rent case would be what happens in court is that if the landlord prevails, there's an amount that is noted in that judgment. It's not collectible as a money judgment, but it is what gives the tenant the right to redeem and remain in the property. So if they exercise their right of redemption, that's the amount that the tenant has to pay in order to address that failure to pay rent action. And if they do that, then they would not, the landlord would not be able to obtain a warrant for restitution.
Okay. Okay. I do thank you for the bill because I think I know regulations need to be where they need to be for the intent. I guess I just need more clarification, so I'd love to have further conversation offline. Thank you. Thank you.
Thank you, Madam Chair. I really love the intent of the bill, of the wonderful bill sponsor. I have two questions, clarifying question regarding oversight and accountability. If we remove the licensing requirement as envisioned by this bill, what specific enforcement mechanism replaces it, number one? And number two, which agency will have authority to investigate a complaint or discipline abusive property manager? There could be few, right? That's the first question.
So, as I mentioned earlier, Delegate, we believe the Attorney General could still, under various different statutes, pursue complaints against landlords alleged by tenants. And more to the point, on the local level, you have counties that can make claims against tenants under their own consumer protection statutes. And if they're failing to maintain the property, as the Vice Chair noted, in some cases, they can refuse to renew the rental housing license for those practices and pursue cases separately for that. So there's a wide variety of avenues that the government, both state and local, could pursue to rectify those situations.
And the second question is regarding consumer protection safeguard. And I believe this license collection agency must carry certain bond, right? I believe $40,000, $50,000, correct?
Mr. Alfred could speak to that, yes.
Yeah.
There's a $50,000 surety bond.
And they have to meet training and the background requirements as well. Is that correct?
That part I don't know yet because I haven't gotten through the application after the last 6 months.
Just my question is, if the property managers are exempt, I'm wondering what financial or regulatory safeguard will protect tenants from fraud or abusive practices?
I think that would just fall under our normal, whether it's insurance coverage or something of that nature, if we were to be sued for some sort of violation.
Thank you.
Thank you. Seeing no further questions, thank you, Delegate Chi and your panel.
Thank you.
We have a couple more favorable, Jessica Zuniga and Matthew Defoe.
Good afternoon, Madam Chair and members of the committee. My name is Jessica Zuniga. I am here today on behalf of the Maryland Affordable Housing Coalition. We represent 185 members in the affordable housing industry, including developers, owners, and property managers. My company, Benton Communities, manages over 6,000 units, primarily in Maryland. Many of our communities are affordable housing regulated by the Maryland DHCD, as well as other federal and local agencies. I echo the comments of my colleagues. We are already in a heavily regulated industry where landlord-tenant law governs conduct and adjudicates disputes. Our core business is not collecting debt, and it seems current landlord-tenant law agrees. When we pursue an eviction for non-payment, we only receive the award of possession and not a monetary judgment. In our company's case, when monies are owed after move-out, the account is sent to a collection agency to pursue those debts. We do not collect post-move-out collections ourselves. Our team handles many responsibilities, with collection of rent and charges being only a small part. In addition to the day-to-day roles my colleagues have mentioned, affordable housing has other demands that include annual income certifications, frequent regulatory file audits and inspections, specialized resident screening processes, constantly changing regulatory rules and processes, and delivery of resident service programming. The past few years have been very challenging for the property management industry. We have experienced record highs in non-payment and evictions, a large increase in eviction filing fees, and increasing costs for utilities, taxes, insurance, services, labor, and goods. The many changes to landlord-tenant law, both at the state and local levels, require additional staff training, more legal costs to ensure compliance, and additional costs surrounding evictions. Our state is in a housing affordability crisis, and more regulation will only continue to add to the cost of housing. Most importantly, we want to do what we do best, which is maintain our assets, provide a high quality of life to our residents, and be good neighbors. By adding more regulations, we will spend less time and money on these things. Thank you.
Thank you, Madam Chair. Members of the committee, for the record, Matt DeFeo. I'm here on behalf of ABC Metro Washington. We're their associate builders and contractors, which represents over 1,500 members in the in the DMV area. So why you ask why the construction trade station is here? Well, we have many allied associate members, especially in Prince George's and Montgomery County, that this touches on. And they weighed in pretty heavily in our joint legislative committee that they wanted us to support this legislation. Some of the points have already been made, especially in those two jurisdictions where the extension of consumer protection already exists. So we see this as a good clarifying bill, basically, that reduces unnecessary burden, and then it just promotes growth within those two jurisdictions, which, for the most part, to be honest, has been pretty stagnant for a few years now. And you look across the river and into Virginia, into the District of Columbia, and you see growth and them taking down some of these red tape barriers. So with that, Madam Chair, we ask for a favorable report for House Bill 433. Thank you.
Thank you both. I don't see any additional questions, so thank you very much. That will conclude the bill hearing on House Bill, I'm sorry, not conclude. I think you got a little worried there. I was just messing around. We have the opposition, who will be coming forth, and we'll begin with Matt Hill, Kira Wilpon-Wellborn, Lisa Sorrow, Chelsea Ortega, and Zafar Shah. And you may begin when ready.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. For the record, I'm Kira Wilpon-Wellborn, the Housing Unit Chief for the Consumer Protection Division in the Office of the Attorney General. The Consumer Protection Act mandates the division take strong protective and preventative steps to investigate unlawful consumer practices, to assist the public in obtaining relief from those practices, and to prevent these practices from occurring in Maryland. As such, the division mediates and investigates complaints from Maryland consumers regarding unfair, abusive, and deceptive trade practices, and seeks to remediate violations of the Act through enforcement actions, including actions against property managers for illegal debt collection activities. Over 1/3 of Marylanders are renters paying significant portions of their income in rent and utilities. These payments mostly go not to the owner of the rental property, but to third-party property management companies. This is true both for large apartment complexes and smaller scattered site rental units within the state. Under the current law, these third-party property managers required to obtain a collection agency license before collecting Marylanders' monies. As the Office of the Attorney General explained in 1980, and as reaffirmed by the appellate court in the Williams v. Erint decision, all rent collectors must be licensed as collection agencies. The statewide oversight of property managers is deeply important to both protect Marylanders before any money is collected by ensuring the property manager is fit to do business within the state, and then to afford opportunities for complaints and accountability when illegal collection activity occurs. Indeed, in the past 5 years alone, the Consumer Protection Division has entered into 3 final orders with property managers for violations of the CPA, including collecting rent and other fees when a collection agency license was not obtained. These final orders address unlawful collection activity by property managers throughout Maryland, including in Montgomery County, in Prince George's County, in Baltimore City, and Baltimore County. And the division's most recent final order resulted in $11.2 million in restitution for consumers harmed by illegal practices. For these reasons, the division requests the committee issue an unfavorable report. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, my name is Matt Hill. I'm an attorney at the Public Justice Center. Thank you for the opportunity to testify. And I appreciate the sponsor's intent to bring more uniformity to the practice around debt collection and property managers. Our concern is that unintentionally, this exemption could embolden certain bad actors who do engage in deceptive and unfair and harassing practices. We see this all the time in our practice. I gave you one very specific example in my testimony, a client I have currently, senior citizen, disabled, worked for the government for 20 years, and she's behind on the rent. And she's trying to move right now into a much more affordable unit. But as she's behind on the rent, she received a notice saying that the property manager, a large building, considers her property abandoned, and they're going to take action to change the locks within 72 hours if they don't hear from her. Oh, and by the way, pay all your rent. The problem was, of course, that they were in regular contact with my client. I was in regular contact with the property management company. This was simply a deceptive, predatory tactic that did cause my client to panic, lose sleep, and call me in sweats saying, am I going to be evicted tomorrow? And I told her, no, you're not going to be evicted tomorrow. This is deceptive. This is unlawful. And I've listed a number of other tactics like that we've seen over the years, including, again, you don't pay the rent, we're going to call ICE. If you don't pay the rent, we're not going to repair your heat. All of those kinds of tactics are extremely concerning. And our concern is that if you remove the enforcement mechanism of licensing, the complaints-driven process through dollar, and the leverage dollar will have to take away someone's license, then you're just going to, again, unintentionally embolden those bad actors. Finally, I just say that rent is essential to property management company. I'm just so surprised to hear the supporters of this bill saying that we just do property management, we don't collect rent. Everything I've heard from them in the past is we just want to be paid the rent. And so I'm very confused about that. Thank you.
Good afternoon, Chair, members of the Economic Matters Committee, Vice Chair. My name is Lisa Sorrow. I'm the Director of Litigation and Advocacy at Community Legal Services. We represent thousands of Maryland tenants every year. I've submitted written testimony with details regarding our court experiences with unlicensed property management companies, including one of the property owners that Ms. Wellborn referenced in Prince George's County. By removing the only objective bright line requirement that gives the state and tenants an objective means of determining who is entitled to recover rent from state regulation, that would be eliminating a critical tool that's available not just to tenants, but also to the Office of the Attorney General and the Office of Financial Regulations. I was taken by the concept that these failure to pay rent cases are not intended to collect a debt. As my colleague said, what I hear every day in court is we don't want to evict these tenants, we just want our money. That's why we're filing these cases. In Maryland, as you know, a tenant has a right to redeem the property. If there is a judgment for possession hanging out there against them, if they pay the rent, if their rent is collected, their debt is collected, then they get to keep their property. They keep the roof over their head. The intent of a failure to pay rent case, the filing, is to get the money. It is debt collection without any question. I would refer you to my written testimony for additional details. We urge an unfavorable report on this bill. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Chelsea Ortega. I'm an attorney at the law firm Santoni, Vacci, and Ortega. I have been a tenants' rights and consumer protection attorney for over 10 years. I have seen many of the practices that my colleague Matt Hill has pointed out, including illegal lockouts by property management companies where tenants lost things like their family members' ashes, their kids' paperwork, artwork, and this I just want to point out that this regulation is not a new law or a new regulation. Large property management companies in Maryland have been licensed for over 7 years. Westminster Management Company, a large management company in Maryland, since 2019 was licensed under MCALA. The Maryland Management Company has been licensed since 2016. This is not something that's new. And to hear that it is simply just not true, members of the committee. I heard Judge Aaron say, I'm sorry, I'm used to talking to judges. I heard committee member Aaron say earlier, Delegate Aaron say, oversight is more important than ever. And we agree. When we have tenants who are being harassed, locked out of their homes, charged illegal fees. And frankly, this isn't just our opinion as far as that failure to pay rent cases are debt collection activities. In the 2022 case, Williams v. ERIT, I'll just read the Appellate Court of Maryland's conclusion. All of the court counts in Ms. Williams' complaint rely on the notion that ERIT conducted debt collection activity by filing FTPR, that's failure to pay rent actions, under Real Property 8401 without the requisite debt collection license required by MCALA. Because we conclude that ERIT's actions did indeed constitute debt collection activity, ERIT was required to possess a debt collection license. Accordingly, we reverse. This has been the law in Maryland. It is not a change. What would be a change would be to remove these protections for tenants when they are more important than ever. And for that reason, we urge an unfavorable report. Thank you.
Hey, good afternoon, Madam Chair, members of the committee. My name is Zafar Shah, Advocacy Director for the Human Right to Housing at Maryland Legal Aid. We operate in all counties of the state, and we see this problem come up time and time again with our clients who are the most economically vulnerable in the state, which is that they are encountering debt collection activities left and right. Not only in their leasing offices, but at their homes when they're being asked to pay rent with not only a knock on the door, but maybe even in some cases a staff person entering their property without permission. The examples you've heard from about calling ICE, we've heard them too. We have clients who've been reported to CPS as a debt collection tactic. Just a matter of record is that when you look at property management company advertising, they believe that debt collection services is their growth industry. That's where they're going to expand their reach. And so the technology and the frequency of debt collection is expanding. This far exceeds just what's happening at court, but what's happening at court is certainly bad enough. The serial filing, duplicative filing, walking out into the hallway with our clients, speaking vulgarities, making threats. There has to be some way, and I think what's urgent for the committee is to consider, if it's not the licensing that already exists, what is it going to be? And it should be something that's stronger as, again, the technology and the domain of these debt collection activities and the intimacy of these debt collectors with low-income renters expands. It's got to be stronger and not being walked back. And so we urge this committee to report unfavorable on this House Bill 433.
Thank you. Ms. Ortega, I like how you elevated Delegate Ahrens to judge, or to justice over there.
My apologies.
Delegate Roberts and then Delegate Adams.
Thank you, Madam Chair. I agree with everything that you said up here. You can't hear me? Okay, sorry, Madam Chair. I agree with everything that you said about the wrongdoings of property managers or property landlords who are treating tenants, wrong and not fixing up their properties and threatening and doing things. You asked a question about we need something stronger. I was just wondering, it seems like what we need is like a slumlord registry with sanctions. And I know that doesn't have anything to do with this bill, but it just seems like I'm just wondering if all the examples that you've given, if it has if it has, or legally, I guess, and you're saying yes, but if it has anything to do, up until what you talked about, and I'm sorry, I don't remember your name, but, and you're an attorney, but until you spoke, no one really clarified that everything that, the examples that they were given had to do with legal debt collection. And I was confused about it too, you know, but I'm just, I mean, if we're looking, and I appreciate this bill because this is a good conversation to have. I just think that because we hear a lot of the bad actors, we do, but you know, I'd like to know how many bad actors are there and who, you know, who's doing what and you know, so that we can have, like, I don't know, it seems like we need data. Everybody's giving data about low income economic situations and everything, but I would like to see data on the bad actors, who they are, the number of them. And I do agree, there should be some strong enforcement. I'm just wondering if I think that this bill gives us an opportunity to have that discussion. I just you know, because if they have sanctions, you know, then you won't be allowed to operate. Period. And maybe I didn't ask a question, and I apologize, Madam Chair, but I think this is a very good discussion, so thank you for your clarifications.
You could say, isn't that so? But anyway, Delegate Adams.
I do that a lot around here, isn't that so? Who called Delegate Aaron's the judge?
That was me.
That's awesome. That's going to stick. I'm going for the video, and we're going to be using that around here. He'll use it, trust me. So I like to stay on the bill, and with respect, the testimony I'm hearing today, candidly, is not on the bill, because if it were on the bill, your testimony is saying that Title VIII is completely ineffective in helping protect tenants, has no teeth, and therefore we've got to come up with some new found way to go after landlords. Isn't that so?
So, no, the difference is that Title VIII, tenants usually need to find an attorney to help them to navigate all of the different statutes and the ins and outs of court. And what we have now with MCALA is a tenant can make a complaint to DLLR about a debt collection abuse that they believe has occurred. So that's the difference.
Let me reinforce. Basically what you just said is that Title VIII is not effective in helping tenants protect themselves against unruly or illegal activity by landlords.
I will say that there are many studies that say that unrepresented tenants do much worse in court than tenants who are represented, which is why we have the ACE bill and the ACE funding and Public Justice Center and legal aid and community legal services of Prince George's County to help tenants navigate rent court and all those.
I'll stick with you on this. Of course they're represented because they get free representation paid for by the state. Is that so?
Tenants who qualify, and I'm a private attorney, but tenants who qualify by income do get free representation, but there are lots of tenants who do not meet those income requirements, who still cannot afford to pay an attorney the rates that an attorney would have, who, you know, suffer legal threats and other things.
So to the AG's office, respectfully, on the bill, the problem that I've got with your testimony, and I've read your opinion on this, is that we've found in law from the 80s or late 70s something that has not been interpreted and or used. And my question is going to go to you as to when did we start interpreting the law in such a way that wraps in property managers? Did this happen last month, last year?
Since 1980.
No. When have you done enforcement actions the way that we're talking about here?
So we have had many enforcement actions against property managers for collecting rents, which is a consumer claim, and I want to make that distinction clear. So there is the MCDCA, which covers the collection of debts, and then there's the MCALA, which is the collection of a consumer claim. So that is money that is not yet debt. So that can be every month on the first, that rent, not debt yet, because it has not been paid, is a consumer claim that is covered by MCALA. So we're talking about two different spheres here. But to your question, the Attorney General's office has interpreted MCALA since 1980 to require all rent collectors to have a collection agency license. And we have enforced that law consistently throughout that time. In the last 5 years, we had our Westminster management case, which was, we charged that in 2019. Westminster, I know that my colleague here had indicated that they obtained that collection agency license in 2019. They actually had collection agency license prior to 2019 and let it lapse. We also had a case against Real Property Management Capital the final order was entered in 2023. I believe our investigation began in 2019. And then most recently, our case against Heather Hill Property Company and Heather Hill Operating Company, in addition to One Wall Management, which was the property management company for the Heather Hill apartments at that time.
So with all that being said, I assume you didn't like the court decision that related to the following. It's, in the quote from the court, it's also unlikely that enacting legislation to protect consumers from predatory debt collection agencies, the General Assembly intended to impose licensure requirements on professional property managers. And so when I'm reading that, and I'm not an attorney, I'm going to readily admit that I'm not, so it doesn't pass the sniff test, what you're saying, because I go back to, are you collecting a debt on par with not paying a mortgage, or is a landlord in a judgment where they get possession of the property, they're not getting money, they're getting their property back? And do you not see the difference between the two?
I think that the important difference is first, the case that you're mentioning is on appeal, and so I don't believe that it's a final determination of the interpretation.
I just said you didn't like it. I didn't say whether it's on appeal. I assume it's on appeal because you didn't like it, but the point is.
Oh, we are not a party to that action.
Then you're following it, and therefore you don't like the decision. Okay. But I'm sorry, continue.
But I do want to, again, delineate the difference between MCALA and MCDCA. So MCALA covers all collection of consumer claims, and I believe that you will hear testimony here from FinReg that can probably provide additional clarification should you have it. But MCALA covers the collection of all consumer claims. That is any money that is not yet in debt. It can include debt, but it doesn't have to be in debt. So it wouldn't apply necessarily to the failure to pay rent actions, because those are actions that are seeking a debt, an unpaid rent amount, which is a debt.
All right, my last question. Thank you, Madam Chair. When I said to the sponsor of the bill that our goal here in Annapolis should be to create bright line, clear paths to compliance with the law, and when I say that you've got Title VIII and you have different regimes, and now this interpretation from the AG's office of this newfound debt collection license, are you concerned as a enforcement agency that you're creating unfair and frankly, in my opinion, unnecessary burdens on business community to comply not with one, not with two, but rather with three different standards? And then furthermore, are you worried that one standard might have a different interpretation in a court of law with another standard? Are you compassionate at all from the business community side that this is creating unworkable mandates on industry?
So,
thank you for answering, and I'll stop there.
Yeah, absolutely. So we are aware that there are property management companies that have a collection agency license, so it doesn't seem to be that big of a burden or a hurdle in order to be able to obtain this license. As an enforcement agency, my concern is the harm Maryland consumers face by interacting with entities that are not being reviewed before money is being collected and then do not have an ability or a means of having important checks and accountability when there are violations of the law. And the MCALA license both
creates a front-end review to ensure that those who are collecting consumer claims have met a minimum level of fitness to do so, and then provides a back-end form of accountability when violations occur. And that accountability can be enforcement actions, it can be the revocation of a license, it could be additional oversight. But those are all important to protect Maryland consumers in an area in which consumers are overwhelmingly paying large portions of their monthly income for housing. Thank you.
Dari?
Thank you, Madam Chair. Thank you for describing all these abusive practices. They're real. And as you heard that from the sponsor panel, the goal of this bill is to create a, number one, uniformity and avoiding treating routine rent collections as a third-party debt collections. Are you thinking, we are wondering that if you have any specific amendment that would suggest that we balance that intent of the bill and with the need to prevent the kinds of abusive practices you described?
I do not have an amendment because I think primarily one of our concerns is if we remove this statewide oversight, then what we have is no statewide accountability. And then we have each jurisdiction, depending on whether there are consumer protection laws, whether there are rental licensing laws, creates a patchwork framework in which there is actually then no standard or consistency in the protections that Maryland consumers face. If I'm renting in St. Mary's County, I want to make sure that my landlord is a collection agency and is able to collect that rent just as if I'm renting in Baltimore County or Wacomico County or Somerset County. It's important to have statewide oversight in this space, and if we remove that statewide oversight, we create a patchwork framework which will result in, I believe, unfair, abusive, and deceptive trade practices that will proliferate through the rental property market.
Thank you.
Thank you. No further questions for this panel. Thank you so much. We have two more in opposition, Kathleen Highland and Tisha Guthrie.
Sorry, Madam Chair. To clarify, was Mr. Borison also on the list?
No. We allow those who sign up.
I did send it in last.
Thank you, Madam Chair. Thank you, Chair, Vice Chair, members of the committee. Good afternoon. My name is Kat Highland, and I'm the Deputy Commissioner with the Office of Financial Regulation, Maryland State Consumer Financial Protection Agency. We respectfully oppose House Bill 433, and I just want to emphasize we're here today not because this bill involves property managers, but because it involves collection agencies. So I just want to get that clear from the get-go here. We want to emphasize that this issue is neither new nor unexpected. It reflects longstanding law, court guidance, and the way the licensing framework has been administered for years by both OFR and the State Collection Agency Licensing Board that the Commissioner chairs. Under Maryland law, entities that collect consumer claims for another must be licensed unless a specific statutory exemption applies. The statute also makes clear that debt collection licensing is a matter reserved exclusively to the state. Under Business Regulation 7104, only the state may require a person to hold a license or pay a fee to operate as a collection agency. That reflects the General Assembly's intent to create a uniform statewide system for regulating debt collection practices. Local business licensing requirements may exist for property managers, but they do not replace, cannot replace, and cannot substitute the state's consumer debt collection framework for licensure. Importantly, it's not just an OFR position. The State Collection Agency Licensing Board, as you can see in their public minutes, has been licensing property management related entities for years. Within the past year alone, the board has approved collection agency licenses for residential and property management companies. In addition, the board has been briefed on rental-related debt collection concerns, including fee practices, utility sub-metering in multi-unit residential properties, approved guidance that explicitly applies to property managers, and all of this history reflects that property-related collection activity is already well within the board's regulatory oversight. Please also look at section 7103 and how we can't duplicate on enforcement actions in Maryland. If one agency brings it, mine can't, and vice versa. They'll lose that protection if this bill passes. Thank you. We urge an unfavorable report.
It's on, really? Okay. Thank you, Chair, Vice Chair, and members of the committee. I'm going to beg your indulgence. I'm legally blind, so it takes me a little longer to read my statements. My name is Tisha Guthrie. I am a member of the Inclusionary Housing Coalition, as well as a Maryland State licensed social worker. I, first of all, would like to say that going through undergrad, followed by 2 years of graduate studies, then sitting for a licensure exam, and then being required by this here state of Maryland every 2 years to prove that my license is still relevant, I think it does speak to the relevance and the importance of licensure. As a renter, I deem this licensing requirement as one of the few regulatory mechanisms available to your constituents as a means of protection from those who may have the slightest inclination to use their muscle and the already established imbalance of power. I'll give you a couple of examples of how this goes beyond just the collection of rent. There are property managers who falsify documents, they manipulate ledgers, they literally terrify their tenants into believing that they owe a debt that they do not. You all probably read articles last year regarding a property management company and a developer in Baltimore who at this here point still owes $800,000 in an overpaid past due water bill. The renters, I know I was, every month paid my water bill. So there needs to be at least some mechanism to hold these debt collectors responsible, and there needs to be a standard by which they stand. So I seriously ask for an unfavorable report on this bill.
Thank you, ma'am. We'll go with Delegate Adams.
Chair, and to Department of Labor, just 2 quick questions, and I think I've done enough back and forth, so it's just really just process from questions to you. The first one is, how many property managers do you think in the state of Maryland would perhaps have to apply for this license?
I know that we have 1,048 collection agencies licensed as of last year. We don't distinguish what the collection agency also does. So if they're also a movie theater, we don't know that, or also a property manager, or also, a hairdresser. We just know that they're doing the collection activity sufficient under MCALA.
How many current license holders in the state of Maryland do you regulate?
Or as of last year, 1,048 collection agencies.
So if I
under
ask,
MCALA.
so if I ask the question in the form of a wild guess, and I don't normally like doing this, but I'm not a lawyer and I'm just going to do it anyhow. Would it surprise you to hear that the number of property managers would far exceed the number of entities you currently license? If I'm asking.
No, it wouldn't surprise me, because when we started discussing how to be licensed with the property management industry last year after they received the letter, we set up a system to handle that volume and to talk through how to get licensed, give predeterminations if possible, and be as focused as on education and compliance as we could.
Yeah, I mean, so I first started hearing about this in the fall of this year, and so what I believe is the case is your burden will be magnified multiple fold. And so the question is that you have deemed yourself in this department able to take the burden of doubling, maybe even tripling or quadrupling the number of people that you license. Is that your testimony?
Only for collection agencies. We license 18,000 entities
but that's my question.
in the state of Maryland.
Yeah. All
Yeah,
right,
we
and
have the capacity. We've discussed this with them. We have a senior escalation contact. We provided the checklist. We did a training in October. We're ready. We've been waiting for this flood, and it still has not arrived.
So, okay, the flood. You mean the flood of people coming in, making application for these licenses?
That's what we're told.
Because the AG is doing this interpretation, as you're anticipating that?
No, because it seems as though either something happened in industry, and I don't want to speculate, maybe more PMCs are doing collection work now than in the past, I have no idea, but suddenly they have approached us with more interest in becoming licensed.
And I only say this with respect, but it's not happening because you're doing outreach in the industry and forming and training public. You just think this is going to happen because at some point the industry at large is going to, especially the ones that don't pay attention day to day, what's going on in Annapolis, are all of a sudden going to show up and say, here's my application for license? Because my question is, that was rhetorical.
Okay.
There's no way in the world you're ready for that. The rhetorical to that is, when you have people who have never had to worry about this license come in and say, well, here's the application, now tell me what I'm supposed to do. Tell me what I'm not supposed to do. Tell me what happens if I violate this, that, or the other. You think that the businesses will have clear paths to compliance with these newfound laws, especially on my prior testimony when there are a series of other regulations and burdens that we put on them on top of this. And I'll leave it with that. That's my last question.
As you've heard in my testimony, those are different regulations and I guess burdens. I don't know. I haven't seen them all. We are the only entity that can issue a collection agency license, and technically it goes through the State Collection Agency Licensing Board after OFR approves.
Yeah.
Compliance has existed for decades now, as you heard in the last panel. So we, again, have no concerns that we could walk them through the process as we have for their peers.
I'm a fan of the Department of Labor. My life in politics started with a thing with the Department of Labor, and the only thing I can share with you is please make sure we work with the business community. This clear path compliant thing means a lot to me.
100% we will, and we don't want the business community, all the other businesses, to have to bear the cost of compliance when we still have to enforce against illegal debt collection activity, but don't have any licensees contributing towards our revenue either.
Okay, thank you. Let me remind committee members that we have many more bills and witnesses today. And we will have an opportunity to discuss all of the bills in subcommittee and in committee going forward. And also just a reminder to witnesses that the window to sign up to testify is 2 days before the bill hearing from 8 a.m. to 6 p.m. If there aren't other questions for this panel, I think that concludes our testimony on House Bill 306, and we're going to move to House Bill, we're moving to House Bill 306. I apologize. That's also Delegate Chi. So Delegate Chi, if you want to bring up your panel.
Thank you, Madam Chair. For the record, Delegate Lily Chi again, here to present HB 306, Manufacturers and Dealers Vehicle Price Listing Transparency. Some of you heard my past bills about price transparency at car dealerships, which would allow car dealers to post the actual sale prices on their own websites. This bill isn't it. I just want to put the first disclaimer out of that, okay? It's a much narrower version that actually passed the Senate and almost passed the House before we ran out of time. In fact, it passed the second reader before we ran out of time dealing with other equally important issues like energy pricing and budget. So this year's bill simply says that the price listed on the dealers' websites are the manufacturer's minimum allowable advertised price, and that there could be possibly a lower price at the dealership. That's it, okay? They still have to list the MAP price, which is the minimum allowable advertised price. But they're allowed to just disclose by saying there might be a lower price at the dealership, which is what they are currently allowed to advertise anyway on the windshields of the cars in their showrooms, okay? So that's all that the bill does, and we are very pleased that the Maryland Auto Dealers Association is now on board. In the past, that they were either opposed or they were silent on this, but now they have struck a compromise and they are pleased to support this bill. So for the new members, I don't know if there are any new members. I don't see them. Okay, so I guess I don't have to explain the context, which simply is to say, by franchise agreement, they have to list certain prices on their own websites or everywhere as dictated by the manufacturers. So this one simply hints that people show up in person could possibly get a lower price. So I urge a favorable report. Oh, I should have mentioned that the name of the bill is in honor of Mr. Jack Fitzgerald, who was a staunch consumer advocate for decades, who contributed extensively to our community's well-being. When he passed last year, the Maryland Auto Dealers Association reached out to me, and we worked together to advance this bill. So thank you for your consideration.
Madam Vice Chair and members of the committee, thank you for having me. My name is Rob Smith, and I'm the president of Fitzgerald Auto Malls, and I appreciate the opportunity to speak in support of HB 306. This bill addresses a simple reality. The way consumers shop for vehicles has fundamentally changed. For today's buyer, their dealer website is the showroom. Most consumers do their research online and often visit only one dealership after they've already made their decision. In that environment, the online price is the most important price in the transaction. Under manufacturer minimum allowable advertised price, or MAP rules, dealers are often prohibited from posting the real selling price of a vehicle online. In many cases, dealers are required to show prices that are higher than what they actually are willing to sell the vehicle for. Dealers are also prohibited from explaining that these higher prices exist because of a manufacturer rule. Manufacturers often say that dealers can disclose real prices in one-on-one communications, but that does not reflect modern consumer behavior. Many consumers are unwilling to provide personal information simply to learn the truth about price. They want transparency before engagement, not after. Ironically, in a physical showroom, dealers are allowed to display any real selling price they choose on a vehicle's windshield. But in the online showroom, where consumers actually shop, those prices are prohibited. When dealers acknowledge or violate MAP rules, manufacturers can retaliate by reducing marketing assistance. That raises dealer costs, distorts competition, and ultimately harms consumers. House Bill 306 is a modest, balanced bill. It does not set prices, it does not prohibit MAP programs, or require any dealer to change how they advertise. It simply allows dealers to truthfully disclose that a manufacturer-mandated price exists and that a lower price may be available. This bill modernizes Maryland law to reflect how consumers actually shop today. For those reasons, I respectfully urge a favorable report on HB 306.
Madam Vice Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers and their 20,000 employees across the state of Maryland. Here today in support of House Bill 306. I think the sponsor and Mr. Smith did an excellent job of explaining the bill. So I'm going to say me too and ask for a favorable report.
Thank you. We love efficient testimony. Are there any questions for this panel? Seeing none, thank you very much. We'll move on. We have one unfavorable, which is Bill Kress.
Thank you, Madam Chair, members of the committee. My name is Bill Kress. I'm here today on behalf of the Alliance for Automotive Innovation, which is a trade association consisting of auto manufacturers and tech companies associated with the auto industry. We are in opposition to the bill, as we have been for the past 2 years. I think this is year 3 for this legislation. I certainly understand the sponsor's intent here, but to be frank, this bill doesn't help consumers and it doesn't help dealers, and let me just go into that briefly. So under cooperative advertising programs that the manufacturers have, we give money to the dealers, they contribute money, and there's regional advertisement. Tied to that is a requirement that the advertisement online and in print all be the same for all dealers. So we have everybody on a level playing field. What will happen with this bill is you'll drive, consumers will be confused, frankly, that there may be a lower price. It may be something better if they go to Fitzgerald's. We're concerned about that. We're concerned about consumers having the bait and switch feeling when they show up and find out that there isn't a lower price available. And frankly, the advertised price really isn't tied to what the price of the vehicle is once you get out the door. Because if you've ever been to a dealership, you know what it's like. You come in, you negotiate on the starting price, there's the trade-in, there's the incentives, there's the rebates, there's the dealer add-ons, there's financing and insurance, there's a markup for the financing. And so all these things add up, and at the end of the day, it's not tethered to that price that you see online, at least not when it's all said and done. So we think that the legislation would be confusing for consumers, and I do appreciate the sponsor's intent here, and she's one of my favorite people in Annapolis. I wasn't here opposed to it, but I am today. So with that, I'll conclude. Thank you, Madam Chair.
Thank you. I thought I was your favorite person, but okay.
You're second.
Good to know. Good to know. Are there any questions for Bill? Okay, thank you. That concludes the hearing on House Bill 306. We're going to move on to House Bill 344. I understand Delegate Rosenberg had to leave and his staff is here to present. And then, do you have a panel or is it just you?
Just me.
It's just you. Okay. You can begin whenever you're ready.
Okay. Members of the committee, I'm Sam McGranahan, testifying on behalf of Delegate Rosenberg. 2 years ago, Delegate Rosenberg was proud to help pass the Gas Price Clarity Act. The law passed with coalition support from WMDA CAR, a group of independent owners of service stations and auto repair shops. Unfortunately, both the Comptroller and Attorney General's offices have made it clear that the wording within the Gas Price Clarity Act was not precise enough to accomplish our intended goal. This bill, House Bill 344, fixes that language and allows for a 2-year-old law to be enforceable. The Gas Price Clarity Act was passed with the intention of prohibiting bait and switch signage. The bill was filled with pro-consumer language requiring uniformity in numerals, dimensions, requiring signs that are readable by motorists, and stating that if one price is listed on a sign, it must be the higher credit price. Throughout the bill, words such as prominently, clearly, and visibly are used repeatedly. Many gas stations throughout our state are still using signing tactics to the intentions of our 2-year-old law, whether deliberately or in effect. In 2024, surveys show that 85% of consumers pay for gas using credit or debit card. Despite this, the lower cash price is usually featured on the station's primary sign, which is elevated, often illuminated. The higher credit price, the price 85% of consumers pay, is far more likely to be displayed on a sandwich board on the ground, blocked from view by shrubbery, traffic, garbage bins, parked cars, or other station advertising. Even when the dimensions of the numerals are identical for the two types of signs, this disparity undermines clarity and visibility. The 2024 law did not address reward clubs, car wash, and other discounts. These specials are now often the most prominently advertised prices. House Bill 344 makes small clarifying revisions to ensure the intent of the original legislation is met. I urge the committee to issue a favorable report on House Bill 344.
Thank you. Are there any questions for the presenter? Seeing none, thank you for your presentation. We're going to go to unfavorable now. We have Kurt McCauley, Mike O'Halloran, Matthew Pica, Sarah Price, and Kaylee Locklear. And whoever wants to start can begin as soon as you sit down.
Will do. Good afternoon, Madam Vice Chair. For the record, my name is Mike O'Halloran, here today representing the Mid-Atlantic Petroleum Distributors Association, which has service stations and convenience stores throughout the state. We are in respectful opposition to the bill before you. The sponsor had mentioned, the bill a couple years ago, which MAPTA, along with others at this table, worked with the sponsor to, kind of iron out some of the issues that she saw, or pardon me, that he saw with the bill, or with the with gas price signage. So we're following the law as it's being enforced. This year's bill, however, what we see, and I think the sponsor actually just kind of touched on it, this bill effectively prohibits a service station from advertising rewards programs. It's what it does at the end of the day. So, what we see is, why we're focusing on the gas station industry, the service station industry in particular is beyond me. But to us, we see no difference between, advertising a discounted price for a gallon of gasoline for a rewards member, or if you get a car wash. Then, if you go to your grocery store and they're advertising 99 cents per pound for bananas if you're a rewards member there. So, again, we're just a little bit perplexed more than anything else as to why this legislation almost routinely comes back year after year. And like I mentioned, 2 years ago, we were favorable with amendment. So with that, we do oppose this year's bill. Thank you.
Thank you. Kurt.
Madam Chair, members of the committee, my name is Kurt McCauley. I represent service stations and convenience stores in the state of Maryland, WMDA. Mike said it all. It is perplexing that the bill is there from 2024. It clearly states that a secondary sign has to be clearly visible to a passing motorist. That means that if it's at night, it's got to be lit, as long as you can see it. The law is there to enforce right now. But this law goes into loyalty cards, membership cards, and a lot of our stations have that. There's no cost to it. Anyone can sign up. It's not, no matter what your income level is, you can be a member, you can be a loyalty member. And it saves them money. I mean, we'd end up with 50 signs on the ground if we had to try to conform to this bill. It doesn't make any sense. And thank you.
Good afternoon, Madam Chair and honorable committee members. Sarah Price on behalf of the Maryland Retailers Alliance. We all know that customers want to know the lowest price for whatever good they're buying. And we know that people are willing to drive extra miles in order to save a couple of pennies on gas. Every time I go back to Cumberland, I'm calling my dad and saying, okay, do I go to the Pit and Go or the Circle K this time? Who's got the lowest price? We do believe that the existing law strikes the right balance between operational flexibility and consumer transparency. People want to know what the lowest price is, and right now they can compare that to the highest price based on the existing signs, which many businesses have already made financial investments in to comply with the existing law. If the impetus for this bill is that gas stations are not displaying signage visibly or correctly, then we need to enforce that law. It requires that signs be displayed prominently, clearly, and visibly. So if that's the problem, let's increase enforcement. But I think that the current bill is appropriate, current law, is appropriate, and we do not need this legislation. Thank you.
Thank you. Kaylee, I had called you with this panel if you want to join them, and then we'll take questions for the whole panel.
Thank you, Madam Vice Chair, and sorry, I just ran from the Senate. The only other point I would make, and I would adopt all the comments that have been made here. Again, sorry for the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in opposition to this bill. I just want to point out that on the Senate side, so we've had this conversation for 7 years. We started with the lowest price of the bill. I'm sure folks talked about that. And now we're in this place that we negotiated for 7 years, where either we have to post both cash and debit card, credit card price, or the higher of the two. That's what the existing law says. On the Senate side, the example keeps coming up of what we could call a bad actor, if you will. Someone keeps parking in front of a sign. And that is apparently what we were told on the Senate side, why this bill came back again and why we're having a conversation all over again about the standard price, which would be the highest price of gasoline. But I would just point you to page 3 of the bill, lines 24 through 27. Current law in that instance just needs to be enforced. That's the bottom line. So there's enforcement mechanisms to deal with the example that the sponsor keeps bringing up. We would urge an unfavorable. We worked on this for a very long time with this committee and with the Senate, and we'd ask you to keep existing law. Thank you.
Thank you. I had Matthew Pica on this panel as well. Is he here? Does anyone know? Okay. Are there questions for this panel? All right, thank you for your testimony.
Thank you.
Thank you.
That concludes the hearing on House Bill 344. We're going to move to House Bill 188, which is my bill. So Delegate Queen is going to come and run our panel. Chris, yes. And Rachel. And Donna. Donna, it's showtime. Yeah, you're good, thank you. All right. Madam Chair, colleagues, for the record, Delegate Lori Charkoudian asking for a favorable report on House Bill 188. This is the Unemployment Insurance Modernization Act. We have had this discussion for many years, so I'll do a quick review of the problems that we're facing and the solutions in this bill. First, I want to start with what unemployment insurance is for. It's for three things. One is to make sure that individuals, when they lose their jobs and during the period when they're searching for the next job, have enough to live on with dignity and without going into debt. So really important for individuals and their families. The second thing that it does is it's a counter-cyclical economic tool. When a community experiences a lot of job loss in a recession or something else like that, if there's less income in that community, the recessionary impacts sort of double and triple in a multiplier effect. And so part of what unemployment insurance does in terms of its counter-cyclical abilities is that it makes sure there's enough money flowing through a community so you don't then also have all the small businesses closed down and the additional effects because people don't have any money to spend. Third, it's important for efficient job matching. When we obviously are supporting people to find jobs when they're unemployed, but we don't want people to be so desperate that they take a job for 2 weeks and then as soon as they find a better job, they leave. That's not efficient for the worker. It's not efficient for the employer. And so to get efficient job matching, people have to have enough to live on while they're finding the right job for themselves. So that's kind of big picture why it's important to have a robust and sufficient unemployment insurance system. In terms of what we have in Maryland, there's two things that this bill addresses. The first thing that it addresses is the benefits. In 2010, we set the benefit level at $430. And if you look at the pattern up until 2010, and when you see some of the slides, we can get you these. Up until 2010, the General Assembly raised the maximum benefit level every 2 or 3 years. So we did a really good job of keeping up with inflation over the course of, let's say, the 90s up until 2010. For some reason in 2010, we stopped doing that. And so we haven't raised, we sort of stopped doing that in the body, in the statute. And so essentially, we haven't raised the maximum benefit level since then. Inflationary impacts mean that the purchasing value of $430 has eroded significantly, and the equivalent in 2026 dollars is roughly $610. And so what this bill does is it sets the maximum benefit level to 40% of the average weekly wage, which is essentially $620. But it also ensures that because it's tying it to the average weekly wage instead of putting a number in statute, we don't have to come back every 2 or 3 years to fix it, or we don't have to come back in 15 years to say, whoops, nobody can live on this anymore. It just goes up automatically. So that's an important piece of what we're doing on the benefit side. The second issue is the trust fund, the Unemployment Insurance Trust Fund. So you heard about this a little bit when the Department of Labor was up here sharing the overview of the trust fund. And the way the trust fund works is that employers are taxed on the first $8,500 of an employee's wages. And they're taxed on the first $8,500 regardless of whether that employee earns $10,000 a year or $2 million a year. And so the tax rates depend on where we are in the table. It depends on how often the employer has let people go. The tax rates are one piece of the conversation, and this bill does not touch the tax rates. This bill does not increase taxes. It does not touch the tax rates in the tax table. But those taxes are paid off of the $8,500 that was set in 1992. So what that means is it would be the equivalent of saying, let's see if the state's budget can be balanced if we have our sales tax 6% on 1992 prices. And let's see if taxing the 1992 prices is enough for us to meet the 2026 needs in our budget. It's a ludicrous idea. And so what this bill does is it takes the $8,500 that was set and not touched since 1992, and it updates it. It doesn't fully update it to inflation, because that would be significantly more than what I'm doing in the bill, but it updates it and it indexes it so that going forward, again, we don't have to have this conversation over and over again. You saw in the presentation that the trust fund goes below the average high cost multiplier in the next few years. That affects what we can borrow money from from the federal level. And then it continues to decrease. And as it goes down, keep in mind that as the trust fund goes down, what it does is it triggers higher tax rates in the tax table. So, so if we don't do anything, if we don't adjust the taxable wage base, we hit points where taxes go up on businesses because we lead to a higher tax table, and that generally happens in recessions. So at a time when businesses are struggling the most, we hit those higher tax tables. So by adjusting the taxable wage base, what we're doing is we're ensuring that we have a smoother collection of income into the trust fund. We will readjust the trust fund so it'll get back up above the average high cost multiplier, and it'll be sort of a healthier trust fund and able to withstand recessions. A bunch of different versions of this are modeled. There's models in my testimony. There's models in the testimony that you'll hear from the Department of Labor. If folks are interested in the detailed models and all the ways we tried to say, like, what's the least amount we could increase the average the taxable wage base and still have a healthy trust fund. You know, that's really what we tried to do to put this bill together. The last thing I want to say is every year that we postpone adjusting the taxable wage base, we will have to adjust it that much higher. So you might recall that one of the things we saw when the Department of Labor was here was that Delaware, I'm not sure if I have these numbers exactly right, but Delaware's is $10,000, let's just say. It's not that high, not that much higher than ours, but because they increased it to that a number of years ago, their trust fund is not in as bad shape as ours is about to be. So each year that we've delayed addressing the taxable wage base means that we have to increase it by more in the year that we finally fix the problem and address trust fund health. I'll stop there. Look forward to questions after we hear from my panel, and we'll start over there.
Good afternoon, Madam Chair. My name is Sean Conley, and I'm a staff attorney at Maryland Legal Aid. And we ask that this committee favorably report and pass House Bill 188. Maryland Legal Aid has represented thousands of people who have filed for unemployment insurance. We believe that this bill is a crucial step in helping people maintain their purchasing power, ensuring that they can cover essential expenses. This bill can help reduce financial strain and mental health challenges associated with job loss. Moreover, people receiving higher benefit amounts are more likely to spend money on goods and services. This can help sustain businesses and ensure better economic stability. Increasing the weekly benefit amount that a claimant is eligible to receive may reduce other public support benefits a person seeks and applies for, and as a result, reduces dependency on public assistance programs. Children in households experiencing unemployment can benefit as well, improving their nutrition, access to health care, and educational outcomes. Sufficient unemployment insurance can put food on the table, pay the rent, and keep a family from falling into poverty during periods of joblessness. We have successfully represented thousands of clients in unemployment insurance cases where the difference made saves their home and makes it possible to appear for job interviews and effectively attain new employment. Maryland last updated the method used to calculate the weekly benefit amount in 2010. This bill would set the maximum weekly benefit amount to 40% of the average weekly wage in the state of Maryland and the minimum amount to 15% each year beginning in 2027. The premiums paid into the system and the weekly benefit amount seriously need updating so that the system remains viable. Maryland Legal Aid urges a favorable report on and passage of House Bill 188. Thank you, Madam Chair.
Thank you, Madam Chair, members of the committee. My name is Christopher Meyer for the Maryland Center on Economic Policy in support of House Bill 188. Unemployment insurance is an essential lifeline for laid-off workers, and it's also among our strongest tools to stabilize the economy and limit job loss during a recession. But our UI system today is deeply inadequate. As of mid-2025, Maryland's unemployment insurance benefits average just $397 a week. In annual terms, that's equivalent to less than $21,000, though of course ordinary UI only lasts a fraction of a year. Maryland is a high-income state, but our UI benefits are below the national average. Actually, average benefits nationwide are higher than our statutory cap. In fact, 32 states have average benefits higher than Maryland's cap. Maryland's weak UI system reinforces racial injustice. As of mid-2025, Black workers in Maryland were 3 times as likely as their white counterparts to be unemployed. That means actively looking for a job but unable to find one. That is the highest disparity of any state during that period. We also had some of the biggest unemployment gaps for Latinx and Asian workers. House Bill 188 would make Maryland's economy more resilient. Laid-off workers put UI benefits straight toward necessities, things like feeding their families, which means those dollars cycle right back into the economy and into local businesses. During a recession, every dollar in UI benefits generates $1.93 in economic activity, according to a 2021 IMF working paper. Milder recessions also mean a stronger fiscal outlook. During the pandemic era, it was a running theme at BRE meetings that federal unemployment expansions were one reason we weren't seeing worst-case scenario revenue collapses. We're facing an uncertain economy and a hostile federal government. Let's make sure that we're prepared for whatever comes next. Thank you. I'm asking for a favorable report.
All right. Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to testify in support of House Bill 188. My name is Rachel Keyes, and I am the Policy Fellow at the CASH Campaign of Maryland. CASH stands for Creating Assets, Savings, and Hope. We promote economic advancement for low to moderate income individuals and families in Baltimore and across Maryland. More than half of our clients earn less than $20,000 per year, with many earning less than $10,000. CASH provides a variety of services, including free tax preparation and benefit screening. Last year, our benefits team worked with over 300 households across the state to receive benefits, including unemployment insurance. Unemployment insurance is a basic and essential safety net for workers who are temporarily unemployed through no fault of their own. Once disconnected from the workforce, it can be difficult to reconnect. UI helps combat some of these barriers to finding employment, like affording food, housing, and transportation. Having a robust safety net protects workers from excessive debt and falling behind in paying their bills. This not only helps them find employment, but ensures once they do find employment, they will not be as financially strained. By the end of 2025, Maryland's unemployment rate had risen more than 1%, meaning more than 130,000 residents had struggled with unemployment. Most recent research shows that 1 in 3 households in Maryland struggle to afford even basic expenses. They should not have to experience greater periods of financial stress due to temporary unemployment. This bill would ensure that Marylanders are better supported during periods of unemployment and are set up for success when they re-enter the workforce. For these reasons, we urge a favorable report for House Bill 188.
Good afternoon, Madam Chair, members of the committee. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO. You have our testimony, and I'm just going to make a few points. One, I am a small business, I pay UI, I pay workers' comp, and I've also had the fortune of going from the lowest tier to the top tier and couldn't get out of it for 3 years because we hired temporary workers over President's Weekend and then had to lay them off. And so the comparison, I've experienced this, but I put it in our annual budget. I know what it's going to be. I know what the costs are going to be. So you've heard all the advantages of unemployment. We are also hearing that some people are trying to waive that it's time that employees contribute, and that would help with the solvency. Let me just give you some facts on that. There's only 3 states that have employee contributions. They're Alaska, New Jersey, and Pennsylvania. Alaska's been doing it since the 1930s. New Jersey's been doing it for decades, and Pennsylvania just did it in 1988. All of them have a much higher contribution on wages, and New Jersey's is 49,700. Alaska is 42,300. Pennsylvania is 10,000, but I will also tell you in all of those states, they do the match of the weekly average salary is at 50%, except for in New Jersey where it's at 60%. And we're proposing here 40%. And I will tell you back in 1992, when labor was still sitting at the table on UI, the agreement was to get to 60% at some time. We're willing to deal with this bill at 40%. And it's not about union members. This is about all of your constituents who lose their employment by no fault of their own. And this is a safety net that keeps our communities and our local economies turning, as well as families. So we urge a favorable report. Thank you.
Yeah, we all, yep. And the whole panel
Yep.
spoken. Okay. Oh, wait, there's a question.
Bill sponsor. So just because I'm reading through the bill, the not the benefit, is it the contribution from the business that's going to increase each year, or?
So what is increasing is right now the tax is on the first $8,500. And it's a tax that's paid on the employer side of the, if you think about a paycheck, right, which side of the paycheck's paid. And that is increasing based on the percentages that are in the bill, roughly, I think it's 10,000, I'm sorry. So it's not the
reach 10,000.
It's not the tax rates that are increasing, it's the amount it's the amount of the salary that we're taxing. So we're increasing the amount that's getting taxed, not the tax rates.
Okay.
Yeah.
And does that increase, like, does it gets to a point where it stops increasing? Or, because I thought I read until you've reached the max.
Sorry, which part of the bill are you talking about?
Where am I?
Do you know what she's asking? Is it? Okay, he thinks he knows what you're asking and he's going to answer.
Yeah, so the employers would be taxed at 16% of the average yearly salary for Marylanders. Okay, and so each year we would calculate the average yearly salary of Marylanders, and 16% of that will be what the employers would contribute instead of the first $8,500 of a employee salary.
Is that your question? I'm not.
Yes, it is. And then is it going to continue to increase every year and like forever?
Yeah, so the reason to do it as an index, the reason that both the benefit level and the taxable wage base are set as indexes of average weekly wage or average annual wage is so that it does increase over time as inflation, as wages increase, as purchasing power decreases, so that we don't have to come back, right? Like we said it in 92 and never fixed it. We said it in 2010 and never fixed it. So it increases over time and we don't have to come back and have the conversation every couple of years.
But do we have some catch up to do?
We do.
Okay. And and we did account for that, and then at some point, does it slow down, or I'm just trying to understand. Once we catch up, what happens once we catch up?
So the sooner we catch up, the sooner we'll have more stability in not jumping between the tax rates. So this is the other part of how UI works is we have tables A, B, C, D, E, and F, and each table has a higher rate, and then each employer has a different experience rating on that table. So if you've laid off a lot of people, you have a higher rate. If you've laid off less people, you have a lower rate. But then also, if the economy is in the toilet, you're gonna be in table F. If the economy is doing well, you're in table A, and somewhere in between, you're in table C. So the sooner we sort of catch up, the sooner we can be sure we're gonna stay in table A, which is the lower rates. If we don't catch up fast enough, then it just means that the tables are gonna just continue to go down to table F, and they're gonna be higher rates. So it's sort of as a self-correcting, it's kind of as a self-correcting system. And so really the catch-up just lets us not go too far down into table E, F, that kind of a thing, which the Department of Labor will go through these numbers with you also, but I think their numbers show that if we don't do this now, we're gonna be in table E in the next few years.
Do you have an idea of when we will have caught up?
If you look at so the tables that I had in my testimony were from older analysis. They just did a new analysis that I just didn't get in time to put into my testimony. But if you look at the Department of Labor's testimony, they have some of the charts in there, and they're going to be presenting on that. And so that would be good to ask them about the modeling that they did.
Okay, all right, thank you. Thank you, Madam Chair.
Thank you, Madam Chair. Hopefully this can be quick, and I just want to try to understand maybe quickly, because there are a lot of unfavorables here. Can you talk about how this model differs from what the Department of Labor is doing or is planning to do? Because I'm not kind of following why is the disagreement. And they didn't say that, they just gave information, but.
The Department of Labor doesn't disagree with the bill.
Okay.
I mean, in fact, the Department of Labor has highlighted that if we don't do, I mean, they're neutral on the bill, but they have highlighted, they will highlight, if we do nothing, the trust fund's gonna be in trouble.
Yeah, that's true. I misspoke. But what is the opposition in regards to the approaches people are having? They're thinking maybe, is it employee contributions? Is it an issue with, getting to the trust fund, making it solvent faster? I'm just trying to understand what some of the opposition may be related to.
Well, I mean, they can speak for themselves, except I can say that I've met with them probably, multiple times in the last few years trying to see if there's a compromise on this, and we haven't been able to reach one. I think for them it's related to what employers are paying into the trust fund. It's their contribution. And that's, again, I'd love to pay my taxes on 1992 prices also, but that's not how taxes work.
Okay.
So I think that's the issue.
Questions? The next panel of favorable, Rico Albacari, Tom Clark, and Ray Baker.
Want to go first?
Good afternoon. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Tom Clark. I represent IBW Local 26. I support HB 188. The present year in the title duly notes that the benefits and how they are calculated are stuck in the past and need to be updated. I'm proud to say that since 2015, Local 26 has had full employment. And we have not been a burden on the unemployment insurance system. It's a good time to be an electrician. Having said that, the time to fix the roof is when the sun is shining. The calculations for employer contributions have not been changed since 1992. The benefits have not increased in the last 16 years. Now is the time to adapt to Maryland life in 2026. Please note the goal of this bill is to rise and limit benefits at 40% of the average weekly salary. Yes, 40% of the average weekly salary to allow a family to survive during a temporary period of unemployment. Although electrical construction is good, we did see a record amount of Maryland federal workers being laid off over the last 13 months. So I ask that we think of everyone in our state who suffers from short-term unemployment and look at this bill and consider these much-needed updates. Thank you, and I ask you for a favorable report.
Thank you, Madam Chair, Madam Vice Chair, committee members. My name is Rico Albuquerque. I'm with IBEW Local 24. We represent more than 3,000 electrical workers from Frederick to Ocean City. Come in front of this committee quite a few times to testify in favor of this bill. A couple of new faces. Nice to meet some of you if I haven't met you yet. You've heard from the worker perspective. You've heard the economic perspective of why unemployment benefits are important for communities. I'm going to try to appeal to perhaps maybe a philosophical perspective. I've sat here before, and I think Delegate Adams has said, you know, what is unemployment insurance for? And I would like to ask you all to think, what do you think those benefits are for? What do you think they provide to communities? What do you think they provide to workers? As someone who's experienced having to survive off of unemployment benefits, I can tell you that, 10 or 15 years ago, that $430 is enough, and today it's not. So if you believe that unemployment insurance benefits are important and you believe that it's important for communities, then you should also, I think, believe that we have to keep pace with inflation, that we have to keep pace with the rising costs of groceries, electrical bills, housing, and all the struggles that Maryland families are facing. For those reasons, I would like to urge the committee to give a favorable report to HB 188. Thank you very much.
Thank you. You did a really nice job.
Thank you.
Non-scripted, too. Very nice. And welcome, President Clark. Any questions for this panel? Seeing none, thank you very much. I'll just call his name one more time. Ray Baker?
He's not here. He had to leave. Thank you.
Okay, thank you. We will now move on to the opposition. Mr. O'Halloran, Carrington Anderson, Hannah Allen, Bill George, Sarah Price. You may begin.
Good afternoon, Madam Chair. Good to be here with you today. For the record, my name is Mike O'Halloran. I'm here today representing NFIB in Maryland, and we are in respectful opposition to House Bill 188. You have my written testimony in front of you, so I don't want to read from it there, certainly. But, look, small businesses are empathetic to the costs, the cost pressures caused by inflation. Main Street is feeling it, too, I can guarantee you. In fact, I pointed that out when the Joint Committee on Unemployment Insurance Oversight met during the interim, because there was a lot of discussion about inflation, a lot of the issues that the sponsor brought up about the dollars and the stretching as far as it did, let's say 20 or 30 years ago. Again, the same thing, and I brought this up during the Oversight Committee, the same thing is true for small businesses. I even broached the Department of Labor more rhetorically about, where's the study on that? The sponsor panel also brought up, and I was actually kind of interested to hear this, they were pointing out the experiences in Pennsylvania and New Jersey specifically about how their replacement rates are higher than here in Maryland, than what's even being proposed in this bill. The interesting thing about Pennsylvania and New Jersey is that employees chip in to the Unemployment Insurance Trust Fund. In fact, when the Department of Labor issued a study by the Upjohn Institute, that was one of the recommendations. That would certainly, I think assuage some of the issues and concerns about the trust fund solvency. Again, I just want to put it in perspective, and I also would like to draw your attention to my written testimony to talk about some of the other cost pressures that small businesses have seen since 2018. So with that, I respectfully request an unfavorable report on House Bill 188. Thank you.
Good afternoon, Madam Chair and honorable committee members. Sarah Price on behalf of the Maryland Retailers Alliance. While we do appreciate the work that has been done on this legislation over the years, we would continue to respectfully urge caution against raising the average weekly unemployment insurance benefit at this time. The solvency of the trust fund, we agree, must remain the priority. And while the fund is currently stable, there are concerns that it could fall below the recommended solvency levels within the next few years, even without the recession. So increasing weekly benefits permanently raises the baseline payouts and accelerates that risk. So to Delegate Roberts' questions, my understanding is yes, if you are indexing it, if the economy improves and weekly wages increase exponentially, so too would the amount that businesses have to pay for the tax. If inflation is the ultimate concern here, there are more measured approaches that can be taken, including temporary adjustments during economic downturns or periodic review triggers rather than automatic increases. And a trigger might be something like, what does solvency look like right now? What changes need to be made to address gaps that we may have in the moment? Ultimately, the question isn't whether inflation matters, because we know that it does. It's just whether the permanent benefit expansion is the right tool. I would also observe that indexing the tax to the average weekly wage in the entire state puts employers in more of our economically disadvantaged districts at an extreme disadvantage. The entire scale of economy is different in these communities, and the businesses operating there would be shouldering a disproportionate operational cost compared to those in the more affluent parts of the state. So we would urge an unfavorable. Thank you.
Good evening, Madam Chair, Madam Vice Chair, members of the committee. For the record, Hannah Allen here today on behalf of the Maryland Chamber of Commerce in respectful opposition to the bill. Like my colleagues have mentioned, one of our primary concerns is the fact that it ties these payments to inflation. We're moving away from a fixed structure to determine what the taxable wage base is and the benefit amounts are, to a percentage of the state's average wage, which will increase over time. From my read of the bill, I don't see any counterbalancing mechanisms listed in there that I know a number of other states that do index have. Things like lowering tax rates, solvency triggers, or automatic decreases when the trust fund is healthy and it hits a certain number. But ultimately, this change, means automatic and ongoing cost increases without future legislative review. We would prefer, and businesses would prefer, for that to come back for debate, so they have more predictability in planning and long-term planning, especially for small businesses. And, I'll mention before permanently increasing employer costs, businesses do need the confidence that the UI system is being administered effectively. A recent audit identified more than $800 million in overpaid benefits that went uncollected, regardless of, when those payments occurred or whose funds they were, federal or state dollars. Employers certainly expect strong oversight of the UI system and timely recovery of overpayments, because ultimately they are the only folks that are fully funding that system. So I'll stop there. Happy to answer any questions. Thank you.
Good evening to the chair, members of the committee. Bill George with the Maryland Municipal League here today in opposition to House Bill 188. This hasn't been touched on, so I'll do it briefly here. So as with the state government, municipal governments and counties are typically reimbursing employers, meaning that they pay 100% of a claimant's award upon being invoiced, as opposed to regularly paying into the UI trust fund through tax payments. Due to the essential services provided by local governments, they're keenly aware of the need for this type of employer retention, which leads to a stable workforce, hence why municipal governments find reimbursement route a cost saver. However, this bill dramatically increases the midpoint benefit amount in 2027 to the tune of almost double the current amount. This would result in a dollar-for-dollar increase for municipal government expenditures. In a sampling of our membership in preparation for the hearing of their current UI payments, this would raise the cost per municipality of some of our smaller towns by the hundreds thousands of dollars for some of our mid-sized towns, tens of thousands for some of our larger cities every year, to a total of hundreds of thousands of dollars cumulatively among our membership. Discussion about the trust fund solvency doesn't really involve our members as they are reimbursing employers. They're not paying regularly into the UI trust fund. Yet we're brought into the bill with the immediate increase in benefit increases. So at their core, municipal governments serve their residents as stewards of public funds. This bill would increase expenditures to the point where we can't simply support it. So we ask for an unfavorable report on House Bill 188. Thank you.
Thank you, Madam Chair, Madam Vice Chair. Carrington Anderson with the Maryland Association of Counties in respectful opposition to House Bill 188 as drafted. I think the panel has done a good job about outlining some of the concerns, and my colleague from MML explained how local governments, both the municipalities and counties, were reimbursable employers. We pay back the trust fund. We don't pay the quarterly unemployment insurance taxes. Something I do want to address before I get into our concern. I don't think there's going to be any county that tells you that they don't support some sort of modernization of this trust fund or of the UI benefits. We see the need for some modernization there. Our concern is that this bill as drafted is still a little too aggressive, both in where the UI benefits increase, the amount that they increase, and also the time frame that this is implemented in. Like my colleague from MML said, this roughly doubles UI benefits. That's the same from counties. Of course, it depends on the county. It depends on what's happening in the economy. And then additionally, the bill last year, last year it was 50% for the maximum. This year it's 40, but that would have been implemented in January 1st of 2028, or the calendar year of 2028. That would have given counties about 2.5 years to implement this. Counties are working on their budgets right now for fiscal year 2027. This bill, it would go into effect of calendar year 2027. So if this bill passes, that's roughly 6 months when most counties' budgets, if they're not already agreed upon, they're almost finalized. So this really doesn't give us enough time to responsibly budget. So again, as drafted, counties would respectfully ask for an unfavorable report, but happy to work with the committee and the sponsor. Thank you very much.
Thank you. We'll go with Delegate Howard and then Vice Chair.
Thank you, Madam Chair. Does anybody know what the federal reimbursement rate is? Because we heard some testimony about federal loss of jobs, and I just quickly looked at it, and it says, Maryland does not directly deposit state funds into the Federal Unemployment Trust Fund as a standard practice. Rather, it administers unemployment compensation for federal employees. So the testimony that we heard about the loss of the federal jobs and the negative effect it would have, that's neither here nor there. Is that, am I right? Does anybody want to take a stab at this? I know you guys are kind of more local, but.
Yeah, Delegate, if I may, certainly I will defer to our good friends at the Department of Labor. I think they could expertly answer that question. But the way I've always understood it is, when there is a federal employee that's laid off, I think you kind of read from it, the Maryland Department of Labor pays the benefits. However, the federal government reimburses.
Yeah, we just act as, we're just administrators of the fund. Okay. I just wanted to get that straight. And then also too, like with minimum wage, we had that a couple of years ago. We had some off ramps that we put on for minimum wage. Is there, I looked at the bill, I didn't see anything in there. Is there any type of off ramps? Is there anything built into the bill where, we could, I don't know, for some unforeseen event? As of right now, again, we're just preliminarily looking at it. Some unforeseen event spirals out of control, like COVID, right? Where we can off ramp this if this type of legislation were to move forward. Is there anything that you guys? I looked, I didn't see anything. I didn't know if you guys have.
No, I don't see, if we're comparing it to the minimum wage off-ramp, which I'd also like to point out, I think that was actually removed from state law when we passed the acceleration a few years ago. But in this particular bill as drafted, I don't see any sort of off-ramp. Should there be, a recession of some sort, and let's say, the taxable wage base was meant to go up X, is there an opportunity for the Department of Labor, let's say, to cut, whatever was supposed to be by percentage, whether that's the, minimum or the maximum, 15% or 40%? I don't see that in this bill, no.
Okay, thank you, guys.
For MML and MACO, the current rate at maximum is 430. The bill puts it at 40% of average weekly wage, which is roughly 600. Would you say that's doubling?
So my testimony was referring to kind of the midpoint between the minimum weekly benefit and the maximum weekly benefit, which my back of the envelope math goes from 240 currently to 440, which to me is almost doubling.
But that number is kind of irrelevant because that's not a number that means anything. There's a formula that determines what somebody actually gets.
Right.
And most people now are at the maximum because the maximum hasn't increased, and it represents a very low sort of a wage rate, so most people are at that point. But the midpoint between the minimum and the maximum is not a relevant number for anything in terms of what we're actually likely to be paying out, just for what it's worth. But thanks, glad we got a chance to clarify where your numbers came from.
Okay, thank you.
Seeing no additional questions, thank you very much for this panel. We have one more opposition, Matt Tafoe, and I would have included you here, but there wasn't another seat, so you're solo.
Thank you, Madam Chair, members of the committee. For the record, Matt Tafoe here on behalf of ABC Maryland, Associated Builders and Contractors. A lot of the points I was going to make were already made in the last panel, so I appreciate that. But one point I want to make is I just got off the phone with a member out of Gambles. They've been around a small, medium-sized general and subcontractor company, and she was on the phone with me. She was like, I understand it's taken away from the 8,500 fixed to, based on the calculation of wages per yearly. And she said the software we use to incorporate that is very complex, and this would be another additional hurdle for them on the front end of the office to calculate their yearly budget. So I don't know if that type of issue was taken into consideration in this bill, but I just want to bring that to the committee's attention. So again, it's unpredictable and potentially raising of the UI taxes the year after year would cause an issue with those small to medium-sized businesses. And also, it was alluded to in the last panel about stakeholder safeguards and off-ramps. We don't see that as the bill is drafted. So with that, Madam Chair, I'll give you back some time, and we ask for unfavorable vote for House Bill 188.
Thank you, Matt. Seeing no questions, thank you very much.
Thank you.
Members will now move on to just informational purposes, and I'm assuming they're going to speak. So we will start with Madam Secretary Wu, Sabrina Steele, Jason Perkins Cohen, and Michael Sears.
Thank you, Madam Chair. I think I'm the only one speaking on behalf of the department. Otherwise, other folks are here to answer questions. Our economist did the modeling. Deputy Secretary Perkins Cohen is running UI right now as our interim lead, and Sabrina Steele is the policy counsel at UI. So we're here to answer your questions. Good afternoon, Madam Chair and Vice Chair and members of the committee. For the record, I'm Portia Wu, Secretary of Maryland Department of Labor, here to provide informational testimony on HB 188. This legislation addresses serious and longstanding challenges in our UI system, and we appreciate the sponsor's leadership. UI is critical to workers, employers, and the state's economy. It helps workers stay connected to the labor force and stabilizes local economies during downturns. A lot of questions have been asked already. I will just touch on a couple of things in the modeling. There is a graph in our written testimony. There are a couple graphs there. You will see those lines look a little bit different, as Delegate Charkoudian alluded to. The legislation, that reflects an updated view of the unemployment picture. We know our unemployment is higher now than it was a year ago. We used an average out of an unemployment of 4.95%, which is the average over the last 35 years, essentially. But this projection assumes going to that more quickly. over the next year or so. We also modeled increasing the taxable wage base in equal steps in 2027, 2028. The bill allows it to go up in 2029, but there's some discretion in between. We just sort of did it equally and spaced it out so you can see what that looks like. I will also note this was touched on earlier about the taxable wage base, and you've heard me say it before. We do have concerns about how UI is highly regressive. Right now, an employer paying a worker $10,000 and $100,000, that employer is paying the same tax on that worker. But when the workers get laid off, the person making $10,000 a year only gets $105 a week in unemployment. The person making $100,000 a year gets $430, even though the employer paid the exact same amount. So, expanding the taxable wage base could help to address some of those regressivity issues. And as we've noted, and as the sponsor testified, the importance of dipping below the average high cost multiple of 1 is when it falls below that measure for a certain period of time, the state can no longer borrow interest free from the federal government. The state has had to borrow against the federal trust fund in other economic downturns. And so it's important that we maintain that option if we can. Sometimes the feds provide relief on that front, sometimes they don't. But particularly if you're a state that has a specific type of economic impact that may be more localized, we cannot count on getting relief from the feds on that point. So without some form of modernization, our modeling shows that trust fund solvency will continue to decline over time. We look forward to working with the committee to address these critical issues. Happy to answer any questions.
Thank you, Secretary Wu. I don't see any questions. And Madam Vice Chair, do you have any? No? Okay. Well, thank you very much for being present for informational purposes. With that said, that concludes the bill hearing on House Bill 188. That concludes our bill hearings for this evening. Members, just a suggestion, if you're able, there is a 6:30 event. Check your emails. If not, you can ask Ms. Joy. Again, not mandated, but there is a 6:30 event this evening. Thank you. We're adjourned.